video is on hold.
1 minute. Actually, here my this laptop is not working due to connection problem. So I am on a phone. Laptop I am trying.
Mr. Vinay, good morning.
Good morning, sir. How are you?
Fine, fine. How are you?
Fine, sir. Fine, sir. Good morning, Birla ji.
Good morning, Vinay ji. कैसे हैं?
Fine, sir. All well.
Good morning, Mr.
Good morning,
Thyagaraj.
Vinay ji. Good morning, Vinay ji. Welcome, Vinay ji.
Thank you, sir. Thank you very much, sir. Is Hyderabad settled? What water is settled in Hyderabad, sir?
Yes, sir. It's very logging in, but anyway,
Okay.
things are a bit controlled since yesterday.
Oh, okay.
Is Mr. Vishnu Raju here? I don't see him on the screen.
He's there. He's there, sir.
Okay, okay, okay.
You'll have to unmute yourself, Mr. Vishnu Vardhan. Unmute yourself.
Okay. Right.
Okay, welcome.
Hi,
Mr.
Welcome,
Raju.
sir. Welcome, Mr. Vardhan ji.
Namaste. Welcome to all of you.
Yes.
Thank you.
సినిమాలో యాక్ట్ చేసి ఇప్పుడే వచ్చినట్టు అవపడుతున్నారు.
Security here.
సార్ సినిమాలో
Yes,
యాక్టర్
welcome,
కాదు
sir.
లైఫ్ లో
Welcome.
యాక్షన్ కదా
సినిమా షూటింగ్ లోకి వెళ్ళి వచ్చినట్టున్నారు అంటున్నా.
రెడీగా ఉన్నారా మీరు?
వెల్కమ్ శేఖర్ రెడ్డి గారు, వెల్కమ్.
Welcome, Shekhar Reddy garu. Welcome.
I think now only Mr. Yoganand has not joined so far.
Well, I thought he said he may join, so he didn't confirm that he's going to join. So, want to wait for some more time?
Yeah, I think we should, because people are still logging in. So maybe in next 2-3 minutes.
1-2 minutes we can wait.
Yeah,
Okay.
3 minutes, and then we can start the initial part.
Okay.
Ankita,
శేఖర్ రెడ్డి గారు,
Mr. Yoganand.
విద్యాధర్, శేఖర్ రెడ్డి గారు, విద్యాధర్, have you contacted?
Yeah, he sent a message that he was in is a meeting actually when we called up. Late night he has sent a message that he was in a meeting. So I think I thought it is too late for him to for us to invite him. Anyway, next time we'll involve him.
To introduce you, our CEO is Miss Kathy Narvane. She is our new CEO, joined a year or two back. And Mr.
I was just about to say new. Thank you, but I've already completed 2 years.
No, before that.
But Mr. Shekhar Reddy, I have interacted with you, I think, for some program in the past.
Okay. No, before what he meant to say is before 2 years I used to come regularly to FAPC.
Okay, so you must start now.
Yeah, definitely. Now we used to do a lot of programs, Kadai and FAPC together. It started with Shekhar Agarwal. He has involved me in the civic committee long ago, maybe 15 years back.
Yes.
Now before that, I think Ramakant has introduced me. Actually, Ramakant, when he was a chairman of the civic committee, he introduced me. So I could not do much justice. But when Shekhar Agarwal came in, he was after me. Almost alternately, he used to talk to me, speak to me, he used to take to the FAPC and various programs he has organized. So, in fact, I told Shekhar Agarwal many times that Ramakant, I think he involved me in this, but I could not do much justice during his period. Now definitely, now Ramakant is there, and you want whatever programs we can actively do it. The other day, I think Prem Kumar Garu has organized one meeting. We shared our all views. All the members have shared what issues to be taken up in the coming months. I think he is aware of that. So we had a very fruitful meeting other day.
When you were national president, we have done one program with Credai national president FAPC. We have done, sir. In
many programs, many programs we have done. On metro also, when a lot of issues were there, metro also we have done many issues on taxation, building routes.
And now you are active in CIA arbitration also. We have done program in ICDR recently, last year.
Yeah. We have done a good program there.
Yeah.
So again, we'll do it one more.
For arbitration, yeah.
Yeah, Murthy Garu.
Good morning, Mr. Bhaskar Reddy. Unmute.
Good morning.
Mr. Irani, unmute.
I request Chair Mr. Prem Kumar and our advisor Shekhar Reddy Garu to please guide our infrastructure committee to conduct many more such events, and by involving the other stakeholders like government also in the webinars, that will be more fruitful and meaningful.
Yes. Certainly, sir.
I'm always available to Prem. I'm just a phone call away from for Prem.
And only a phone call away from each other.
No, you have to take a lead as a chair.
Yeah.
You have to take a lead. You tell us what you want. We are there to back you anytime.
Oh, thank you, always. Thank you.
FTCCI looks forward to take the best practices of your mighty CIA organization. And also Credai.
Pardon me?
Also Credai also.
Yeah.
So I can see almost 80 participants already joined.
Start.
So So maybe we can start the initial part, and by then they'll be able to join in.
We can
Should we begin?
do, Ramakant and Madam, we can do some seminars on the sustainability. No, environment point of view, nature point of view. Is the leader in that. We can do certain programs for all sectors, not only real estate infra. For all sectors, we can do the program.
Sure.
Also on recent floods, also there is a burning issue.
Yeah.
Yeah, I agree with Mr. Inani. Yeah, it's a recent floods. Basically, as the civic body says, the encroachments, nalas, which was the major issue, and the lot of casualties happened in last 4 days. And this is also a burning issue in present situation, where the Hyderabad is suffering.
No, what my suggestion is, we should seriously do a program wherein we should come out with a solution to the government. See, we should recommend it. We should, if required, we should engage a professional consultant. They have the actually list. In fact, they have circulated the recently list also, which are the colonies. So they're submerging whenever the heavy rain. So what is the exactly, the solution for that? We should come out with a paper, not just conducting just a seminar and after that forgetting. This is what happening for the last 2-3 decades. It's not a new issue today, but we should come out with what we should be the solution for that. I think that will be helpful to the government.
Yes, sir.
This year, the floods were more affected in the periphery area of the city, not in the traditional areas near the city or like that.
I think the old city was also badly affected.
Not much than the new city.
Oh, really? Oh.
Yeah. So it's basically the Toli Chowki, Mehdipatnam, and this nearby tank areas, Miralam tank. The newly developed areas are affected badly because of poor infrastructure and again the encroachments which are illegal done there. So they are suffering a lot.
And even the airport road, not heard previously, also was badly affected.
I think we can start the meeting.
Yes.
Yeah, 11:10. Yeah.
Sure. So maybe if I can request all of you to mute yourself, and then when I call out the name, maybe you can unmute yourself.
Mr. Yoganand sir will be joining in 2 minutes. He just told me.
In 2 minutes?
Yes, ma'am. In 2 minutes.
Okay, then we'll wait for 2 minutes.
I think you can start your introductory remarks, madam. I
Sure.
will welcome in my speech. You
Sure.
can proceed. Yes.
Sure. So, good morning, everyone. Wish you all a happy Navratri. It's quite an auspicious day. We are starting on the first day of the Navratri on such a crucial topic. And I can see almost 87 delegates who have already logged in so far. And I believe that our team has around 100 plus delegates who have registered. So I'm sure they'll be able to join in course of time. A very warm welcome to all of you, our president, our senior vice president, Mr. Ramakant Inani and Mr. Vardhan Reddy. Also, welcome to Mr. Prem Kumar, who is the chair of our Infrastructure, Real Estate and Smart Cities Committee. And Mr. Abhay Kumar Jain, chair again of our Legal Affairs, Alternate Dispute and Resolution Committee. Mr. Shyam Sundar Agarwal, co-chair of the Legal Committee. So thanks to both the committees. Because of your initiative, I think we were able to put up this webinar together. Also, special welcome to Mr. Shekhar Reddy, who I believe 2 years back, he was very closely associated with the FTCCI, and I request you, sir, to once again please join in the deliberations of the FTCCI. Also, I welcome Mr. CA Vinay Thyagaraj, Chartered Accountant, Bangalore, who is going to be our moderator for the panel discussion on the RERA overview, legal aspect and compliances. Our panelists, Mr. D. Vishnu, Vardhan, Raju, former District Registrar, Registration Department, Government of Telangana. Mr. Nipun Singhvi, advocate from Ahmadabad. CA Mahadev Birla, Chartered Accountant, Ahmadabad. So a very warm welcome to all of you. And I believe Mr. Yoganand, who is also the advisor of the Infrastructure, Real Estate and Smart Cities Committee, would be joining us shortly. So thank you everyone for joining in this morning on Saturday. And I now request our President, Mr. Inani, to kindly welcome the guests.
Thank you, Ms. Khyati, our CEO. I hope I am audible, no?
Yeah.
I am audible? Engineer Mr. C. Shekhar Reddy, Past President, CREDAI, Chairman and Managing Director of CSR Estates, Chairman of CII, IGBC, Hyderabad, and advisor to our committee. Engineer Mr. G. Yoganand, Chairman and MD, Manjira Constructions, and our advisor to our committee, Infrastructure Committee. Mr. D. Vishnu, Vardhan, Raju, former District Registrar, Registration Department, Government of Telangana. The guest speakers, Mr. Nipun Singhvi, Advocate, Mr. C. A. Mahadev Birla, Chartered Accountant, and my colleagues, Mr. K. Bhaskar Reddy, Senior VP, FTCCI, Mr. Anil Agarwal, Vice President, FTCCI, and Mr. P. Prem Kumar, Chair, Infra Committee, FTCCI, Mr. Abhay Kumar Jain, Chair, and Mr. Shyam Sundar Agarwal, Co-Chair, our Legal Affairs and ADR Committee, members of MC Management Committee, past presidents, members of FTCCI, distinguished guests and invitees, participants, ladies and gentlemen, very good morning to all of you. I am extremely happy to welcome you all to the webinar on Real Estate Regulation Act, that is RERA, overview, legal aspects and compliances. I also welcome the distinguished panelists to the webinar. The RERA Act 2016 was enacted by Parliament, came into effect in the country from May 2017. The government of Telangana also notified the state rules in 2017 for regulation and promotion of real estate sector in the state of Telangana. The introduction of RERA is of great importance for the real estate sector, as it is one of the leading revenue and employment generating sector of our country, and it needed some transparency and a regulating authority to keep a check on transactions dealt by the developers. RERA came as a comforting breeze for the buyers in building industry because overcharging on area, bad construction quality, delay in delivery of projects, not following the sanction plans were common problems before the commencement of this act. The existence of RERA is not only protecting the interest of the home buyers, but also benefiting the builders because of greater transparency. Most of the states have established their own RERA offices where they work under the established rules and regulations. Though the act is not retrospective in nature, it mandates every project to be registered with the respective state RERA offices by promoters of the company within 3 months of the commencement of the act. The government
Is it only me who can't hear, or is it?
No, I can't hear either.
No, all of us. So I think there is a connectivity issue.
I can't hear anything now suddenly.
No, Kathy, please check with connectivity, na, with our.
But Mr. Inani is in his office.
Let him stop the video and he can speak. So that.
Okay, I think he is logged off and. So I think we'll move ahead, and I request the chair of the Infrastructure, Real Estate and Smart Cities Committee, Mr. P. Prem Kumar, to kindly give the introductory remarks.
Good morning and welcome once again to this webinar on RERA, an overview.
Sorry, Prem Kumar ji, just to interrupt.
Oh yeah, please come in, please come in.
My connectivity was lost. So, Government of Telangana for bringing the TS, BPAS and the Dharni facilities. And without going much into the detail, I am confident that today's webinar with Galaxy of experts will enlighten us on the RERA Act overview, legal aspects and compliances to be followed for hassle-free clearances and growth of real estate sector in the country, especially in the state of Telangana. Thank you. Please go ahead.
Oh, may I?
Yes, please. Yes, please.
Yeah. So, good morning, and we are looking forward to this very interesting session on RERA. And at the outset, I would like to acknowledge that this webinar and subject has been initiated by Mr. Abhay Jain, Chairman of the Legal Affairs and ADR Committee. And well, he had done a lot of groundwork on this. And our president, Mr. Ramakant Inani, very proactive, very hands-on, I must say. He suggested that this webinar may be jointly organized by both the legal and real estate committees. And that's how we are here. And thanks a lot to Mr. Abhay Jain for all the initiative that he has taken, and also Mr. Shyam Sundar Agarwal. Well, the general feeling is that RERA is an act meant to only protect the interests of the purchasers. But in reality, RERA is playing a very big role in promoting real estate development by bringing about transparency, which in turn would bring in more confidence and more investment in real estate. Well, as per a study done by JLL, the Real Estate Transparency Index in India has gone better from 39 to 34 because of RERA, GST and affordable housing. And we are only a rank away from countries like Singapore, Hong Kong and Switzerland, which is big news to me. Well, because of this ongoing pandemic, the whole country has taken a back step, and these tough times force us to come up with better strategies and for protecting and developing real estate and inculcating best practices. And I'm sure that sessions like this would help us to bring out extraordinary solutions in these extraordinary times. Well, we are happy to have the presence of our Senior Vice President also here, Mr. Bhaskar Reddy. And of course, Mr. Shekhar Reddy, the well-known person who's at the moment the chairman of CII, IGBC, and also the advisor of our committee at FTCCI. I don't know if Mr. Yoganand has joined us yet. I'm sure he will very soon. We are happy to have his presence also in our committee as an advisor, and it's a big help to have a real estate developer of his stature with us. We look forward to an interesting session with our esteemed panelists, Mr. Vishnu, Raju, a very eloquent and a very strong speaker and very strong on his subject. He was former district registrar and president of the AP Sub-Registrars Association. We'll happy to have Mr. Nipun Singhvi, eminent advocate from Ahmadabad, Mr. Thyagaraj, chartered accountant and leading RERA consultant based at Bangalore with offices in Chennai and Hyderabad, and Mr. Mahadev Birla, leading chartered accountant from Ahmadabad. Well, this program, I think, I was told has close to about 250 registrations, and in addition to all those participants on YouTube, and a lot of hard work has been done by the FTCCI secretary with our CEO Keti Narwane, and especially the program coordinator Ankita. I think she worked very hard. with a lot of commitment and very, very meticulous follow-up. We look forward to a very interesting and a very informative webinar. Thank you.
Thank you so much, Mr. Prem Kumar, for your introductory remarks and also all your praises. You have made our day today. And I now request Mr. C. Shekhar Reddy, the advisor of our Infrastructure, Real Estate and Smart Cities Committee, to kindly deliver the special address.
Yeah, thank you. Ramakant Inani ji, President FTCCI, Sri Bhaskar Reddy Garu, Senior Vice President, and Sri Anil Agarwal ji, Vice President, my friend Prem Kumar, Chair for the Infrastructure Sector, and Mr. Abhay Jain, and other the speakers and panelists, Mr. Yoganand, Vishnu, Vardhan, Raju Garu, Nipun Singhvi, Advocate, Vinay, Chartered Accountant from Bangalore, Mahadev, Chartered Accountant, other participants and friends. Good morning to everybody. So first of all, thank you Ramakant and other FTCCI team for inviting me to speak on this occasion. See, some of the panelists are from outside the Telangana. I would like to brief them what exactly happened for the last 2 decades in the state, how we progress, how we evolved here. See, the ease of doing business, I think we initiated almost 2 decades back in the combined United Andhra Pradesh. And before 2006, we used to have a lot of thousands of cases against the projects, because a lot of violations used to take place. In very few people, I can say, in the entire combined state, they have taken occupant certificate, which is actually mandatory as per the act also. So this was the scenario, and we have taken a big movement. Like an NGO, we have taken a big movement. We convinced all the opposition leaders, the NGOs, media, the government officials, everybody. In fact, when they brought in a white paper, we have brought in a counter white paper, we published the newspapers. What you said is not right. These are the things, these are the issues, these are the solutions. We did very, I can say, I don't think anybody in the Asian countries have put up so much of efforts in bringing to the notice of all the stakeholders that these things are happening in the society, how long it will go. And a teacher, a doctor gets a good respect. Whereas roti, kapada, makan, see, actually they are important things, basic requirement. But government, initially, they have done extremely good job, and the housing board has done in providing the housing to all the employees and other sections of the society. But over a period of time, they slowly lost that. Private sector has stepped in. But private sector, when they stepped in, they could not get that respect. See, they are supposed to get a respect like a doctor and a teacher. So we were thinking a lot on that. Why, when we are doing for a noble cause, no doubt there's a profit in this business, but we are doing good thing for the society. So why it is happening is, in every assembly there is used to be some negative remarks on the sector, or in most of the newspapers those days, front box item used to be against us. So we were totally done, informed all the sectors, all the stakeholders involved in the society, what the rules are there, which are not right. Maybe decades back, Britishers might have initiated those rules. Too many parameters to regulate the same building in a given plot. So we struggled like anything. We approached everybody, we convinced, and then out of the box, a building regulations we brought in 2006 by GO number 86, which is, I think, initially some people criticized. During the process also, some of our own members also criticized, but we went ahead to bring respect to them and their family, and have a peace of mind, peace of life after completing the project. We were going around the courts, those many deviations were there, and people, I'm telling you frankly, the people who are known for their position, for their respect in the society, they used to speak a lot of things on the dais. When they come out of the dais, they used to tell the developers, without deviation, where is the profit? So, and these such people in the society used to buy from a persons who are deviating and giving at a lesser cost. That is what happening. So we have taken a step. No, we have to put a full stop to this and bring in a lot of reforms. The unorganized sector should be brought into organized sector, and they should get the respect. That is how we started a great movement. The support of all the stakeholders, and at that time, the Builders Forum was very active with the limited members. Thereafter, we have formed a CREDI at the national level. I was one of the founding members. I continued about 14 to 16 years as vice president. Then I became a national president. And I know in and out of every draft, every line of this draft initiated in the government of India. We had several conferences in Vigyan Bhavan, and even ministry, several dozens of meetings we have with all the stakeholders across the country. But over a period of time, it has come to certain level. It is acceptable, because why I'm telling you is, before RERA coming, our RERA started in 2006. Because our rules, Vishnu, Vardhan, Raju garu, Prem and other colleagues knows here, we have a lot of ease of doing business we brought in the building rules, Vastu compliant. See, first time we brought in a licensed developer, first time in the state. Then 10% of the built up space to be constructed has to be given by way of affidavit to the local body, and local body in turn will put it in the prohibited register in the sub-registrar. So when we get occupancy certificate, this will be released. Otherwise, the occupancy certificate, if you don't get occupancy certificate, the 10% will be forfeited by the government, by the corporation, and the license will be cancelled. The builder will be blacklisted. It's all we have imposed on us. It's a self-enforcement, which is first of its kind in the country, or maybe in the Asia. Before that, we had some FDR system, something which all failed. A lot of malpractices were there. But 2006 onwards, if you see, all the professional developers, everybody is getting an OC, and the perfect title is given to the end consumer. This is a major achievement. And to decongest the city, we simplified our building rules, and our concentration was outside the periphery of the city. Whatever you are seeing today, periphery of the city, how all these investors, big companies, global companies, or pan-India developers have come into Hyderabad because of GO number 86, because the unlimited FSI, sky is the limit, but they are well balanced. There is impact fee. There are a lot of regulations to control that. We simplified the occupancy certificate also. Earlier it's cumbersome, but we made it very simple. Only few parameters. See the road width, abutting road width, setback, number of floors you can count outside the building, and parking. That's all. Later on, one we have added is the land use also we added. This very simple occupancy certificate we have made it. And provisional occupancy also can be given. That provision also be given in time of hardship. Somebody cannot further go, take up the project. Middle of the project, they want to stop it. They can take it to that extent also. It's a very practical GO. Many things are there and it has given a huge boost to the real estate sector and investments in the state. Not only that, even today, the affordable housing is available in Hyderabad. When compared, I'm not comparing Bombay, Calcutta, Delhi. When compared to tier 2 city, tier 3 cities also in the periphery Hyderabad, we get a lot of affordable house. This is what just I want to bring in. Even during the preliminary the discussions with the ministry, I told them, why are you bringing one more hurdle, duplicating whatever the GHMC or HMD is doing? Adopt our rules. GO number 86, which has a what you call tribunal also, ombudsman also. Everything is inbuilt. It's all pro customer also. Why do you bring the RERA? You can also simultaneously change the building rules also. We made it, but they had a different intention. Government of India, they went ahead. They brought in this thing, and we welcomed also. Every time we welcomed it. And I would like to pose some of the questions to our panelists, or maybe my views to them, so that while they are interacting, they can also look into my issues. So during the draft situation also, we said this is going to be one more roadblock, one more speed breaker for corruption and time. And we are in favor of RERA, but we want online registration. We repeatedly, yes, together we argued with the ministry. They said definitely we'll do it online, but give us at least 1 year time. Meanwhile, the entire infrastructure will be developed across the country. And last year when we have done, we invited Mr. Somesh Kumar Garu, who is the chairman of the RERA. Also, we have told him, sir, this is what online is required. Like thousands of crores we are doing transaction over online with RTGS or credit card. Any transaction we are doing, this is not a big issue. Because here, what is happening is, the entire, say, I divide this entire format for the RERA, whatever we have to upload into Part A, Part B. Part A is all the technical issues which we already submitted to GHMC. That thing, we initially we have requested the authorities that as it is, they can upload, while sanctioning the permission, they can upload Part A into the website of the RERA. So we need not repeat that. Part B is about your project delivery schedule and the specifications, the payments, everything. Part B. The moment I upload the Part B, automatically it should give me the number, RERA number. There's nothing much to this. They need not scrutinize much because everything is already. So accordingly, the GHMC or local bodies across the country have to change their building application format and the plans. On the plan also, we give the areas and everything. So on that also, they should write the carpet area and other common areas, everything. So that origin itself, we are building a data. That data is useful in the brochure, agreement, sale deed, everywhere. That is the basis. Even property tax also can be charged on that. So this was it's a very simple thing. I think it should be our request to the panelists also, or the FTCCI. At the earliest, we should see that all the RERA application which was uploaded by the applicant, on the spot, it has to give a number. That is a major request. And another major issue, which I think some advocates are also there, Nipun Singhvi is there, is my personal view. Maybe you can analyze, and the other panelists also can analyze. See why we are not falling under the works contract. Why we are coming under the RERA. The RERA is defined our role. Suppose you are as a promoter, if you are constructing and selling apartments with occupancy certificate, everything, you are registering, you are paying total consideration, your every transparency is there, clarity is there. So this is defined by RERA. So my argument is, when if it's a works contract, my service is there, I go to works contract, I won't fall under RERA. When I am treated as under RERA, my product is defined. What I am going to do, I have taken a building permission, it is there. RERA I have registered. So my end product is apartment, a built up space. So immobile property. So for all RERA registered projects, there should not be any GST. This is my personal view. It can be debatable. So that government of India should consider this. The second thing is project funding also, because like SEBI, there's a regulator, they do a lot of due diligence. Here also our regulator, after doing the due diligence, only they are giving. So why should not the bankers come forward and give the project funding on priority basis at a lesser rate of interest? The other states, resident welfare associations are registered very smoothly. I think in our state, we have certain issues in that. Then phase-wise registration of the projects is allowed as per the act, as per the rule. But our people have somehow, they are withholding something. There is a clarity. Escrow account is not mentioned anywhere in the act or in the rules or anywhere during our discussion also. Maybe some people are asking without knowing there has to be escrow account. There has to be a separate account, not escrow account. So on that also, you can give a clarification on that. And on our request, because we have made a case before the authority, before the minister, when all the stakeholders are there. See, similar to a consumer, a developer also consumer is paying huge money to different agencies, but in spite of that, he is not getting that NOCs and permissions. So developer is also a consumer. So unless you address the grievances of the developer consumer, a developer consumer cannot address deliver the product to the end user at a right time, right quality as per the RERA. So we have put this right. I myself put this from the beginning, this very strong argument. Even the then Minister Kumari Sheljaji also appreciated this. So even today, even because of this argument, there is a section brought in, new section. Therein, the RERA authority can, on behalf of the builders community, can talk to and call them all the stakeholders. They can talk all the stakeholders where NOCs are struck or connections are required, permissions are required. RERA authority can call them, and they are the ambassadors. They can represent the grievances of the industry. That provision is given. They can also promote affordable housing, skill development, green space, sustainability. So this is what on our request that they incorporated. But most of the developers in the other states also, they are not utilizing the services of the RERA authorities. I informed the Sumesh Kumarji also about this. So this is one. Another last thing, I think I request the panelists and all the knowledgeable persons here to come out with their solution. One is a lot of people are doing pre-launch schemes. So as per the act, it is not possible unless you register with RERA. I think there need to be some amendment, some flex, or they can ask the government can bring amendment. Yes, you can do pre-launches, but entire consideration you put it in a separate account, which they will not have any right to draw that account. There's some arrangement has to come in. Second thing is one innovative scheme. See, we are not as a body, as association, any association, we are not against any individual promoters, but we want to have win-win situation for everybody, all the stakeholders. Now, in the recent past, something is happening, and some associations also raised this in the newspapers also. Here the intention of the RERA is to safeguard the interest of the consumer and the promoter, both. But here, both are not covered here. Some people are going in a different angle by, they are coming in a different route. They are not following RERA rules. They are asking the purchaser to buy undivided share the land from a landowner and give it a development to the developer, that 100 square meters, something like that, 100 square yards, and give the development that every flat owner becomes a landowner. So that those people are not registering. Even the purchaser also will lose the right if it's not registered, or if he is a landlord, if he's not a consumer, he will lose the right. Tomorrow something happens to the project. So on this also, I request all the panelist experts to express their views. If it is the right, let everybody follow that right. So it should not be only for a small segment of the people. They violate the entire thing. And if the government feels that this is also right procedure, we all go in the direction. So let the transparency should come in, and being experts in other states also across the country you are practicing. So I request you to just take my views as some of the points also while speaking, and you can also express your views, so that also we can also learn, and my other friends also who have participated also they will also have the clarity, because when we are putting a lot of investments, we should know where do we stand. And one fine morning, somebody should not come and unnecessarily fall on these developer friends. This is a precaution I'm telling. So thank you once again to the FTCCI and Ramakant, the Prem and other colleagues. Thank you very much. Thank you.
Thank you, Shekhar Reddy garu. Thank you.
Thank you so much, Mr. Shekhar Reddy, for sharing your thoughts and in-depth knowledge. And I'm sure few of your requests will be discussed today. We have a moderator and panelist, and if there's anything that needs to be done as a follow-up, we'll be happy to do that. And there's no debate on the fact, the significance of this sector, which is the second largest employment generating. So there's no debate on that, and we must work towards it. I now request our chair and co-chair of the Legal Affairs and Alternate Dispute Resolution Committee, Mr. Abhay Kumar Jain and Mr. Shyam Sundar, to please introduce our moderator and panelist.
Good morning to all, one and all, and I welcome to all to this seminar on RERA. Coming to the panelists, we are very esteemed panelist and moderator. So I will be first, our senior person is there, Mr. D. Vishnu Vardhan Raju. He is a former deputy registrar of the stamps, and he has wide knowledge in the not only the real estate areas, stamp issues on capital gains or other areas. Also, he is having wide practical experience. So I think today's many of the queries he can throw light and enlighten us. Now coming to the second speaker, Nipun Singhvi, he's a practicing advocate. He's a chartered accountant, CS, LLB, Master in Law, certified Fortunate IFRS Bank Auditor, qualified independent director. Have been World Bank member of the World Bank Insolvency Group on Train the Trainers jointly with IBBI. Regular faculty in ICI, ICCI, Nationalized Bank and other areas. He is expert on corporate, commercial, RERA and insolvency laws, and has advised and handled insolvency cases having debt worth more than 1 lakh crores and important cases like JP Infratech, Landco Infra, Isar Steels, Isar Oil, Isar Shipping, Reliance Naval and Engineering, Gujarat Ambuja, Syntex Industry, Digjam Limited, and Gopala Polyplus Limited. He has been a very financial activist also. I remember that he has filed one PIL in Ahmadabad bench, and yet RERA tribunal was not there. I think with this PIL, he got successful and RERA tribunal was constituted. So, and he files, he's a very good social activist and RTA activist. He files regularly PILs for the burning social issues. He has represented PIL on social cause unfortunate Surat fire incidents. He has the removal of caste in OBC list and formation of Parliament Commission, parking fee charge illegally, food price to be allowed in multiplexes, formation of policy in the towing of vehicles, RERA appellate tribunal appointment of technical member in Parliament Tribunal, coronavirus deferment of hearings before RERA and tribunal, COVID realizations to builders. And he has also filed as an RTI activist disclosure of willful defaulters by SBI for the first time RERA tribunal appointment, NCLT members appointment without approval of law ministry. With this introduction of Nipun Singhvi, I welcome him and I thank him for readily accepting. In fact, he is the most sought corporate lawyer and speaker in today's corporate world. So now I request my co-chair Shamsundar Agarwal to introduce other two speakers.
Yeah, I hope now I'm audible and welcome. Good morning all. It's a privilege to be part of this webinar, which is associated with FTCCI and conducted well under the guidance of Mr. Inani, who is the president, and with the help of Ms. Khyati Narnave, CEO of FTCCI. Presently, the burning issue of RERA, which is an important factor and Vice Regent Act is enacted in 2016. The important factors has to be discussed, and I welcome a very prominent member and panelist in today's webinar, Sri Mahadev Birla ji. By profession, he is a chartered accountant from Ahmadabad, and to his profile, he is working very hard on this subject that he has since 2008. He is into this field, and the important factor, I'll just cut short the introduction because he has a very beautiful and big profile of his, but in today's webinar, the important factor is RERA. So his RERA list is very big. He has written a lot of books, especially the headliners from 1 to 22. If I read just a few, that is registration under RERA, which is an important factor. GST on real estate sector. As just now, Mr. Shekhar Reddy also insisted that whether it should be imposed or not. So he has already envisaged and written certain books on it. He will be reporting to it, and especially legal remedies and complaint procedure, which is an important factor in RERA, which he is a very master into that. So I welcome him on this dais to put his special words and experiences to be shared for the betterment of the society and even the people who are professional into this factor and waiting for his real inputs. I welcome Mr. Mahadev Birla ji on this dais, and the second panelist and also the moderator of this today's webinar, Mr. Vinay Thyagaraj. I mean, again, the introduction cannot be given in a very simple manner, but again, it's part of my job today. He is a chartered accountant with the firm Venu and Vinay Chartered Accountants and practicing since 20 years. Specialist in consulting, structuring, and taxation. And he has traveled all over the South, deliberating, discussing the technical points and papers on RERA, and presented more than 150 technical papers on RERA, industries, professionals, and to assist the home buyers, law universities, and public at large. Because the subject today is sometimes RERA, it feels that it is only for the buyer. But from today's professional point of view, it is always deemed as even the builders are part of this industry where the investors are involved to invest his huge money in this real estate sector. And the subject, as we said, real estate is the main factorism to be discussed with FTCI, as also discussed with, by Sri Shekhar Reddy sir. So the commandment and the knowledge with Mr. Vinay Thyagaraj is very huge. He's heading served the technical committees of SIRC and ICI, presently part of Governing Council of NEREDCO, that is National Real Estate Development Council of Karnataka chapter. And he's also having a financial consultant at RERA, that is very important factor. And lastly, with not least, as given to me as part of the personal profile, He's having wife called Sirisha and 2 sons, Anirudh and Anurag. All the best for this, and we are welcoming you to highlight some of the subjects. And from my experience, which I got to know about Mr. Vinay Thyagaraj, is he is also called Tax Guru. So this is something, a title already he is holding. So we will be benefiting all his knowledge for the betterment of this subject. I welcome Mr. Thyagaraj on this dais, and also all the dignitaries, because I could not introduce in length. We are short of time also. We would like to enlighten the subject first. So I again congratulate, welcome, and try to see the best inputs of today's webinar. Thank you all.
Thank you so much, Mr. Abhay Kumar Jain and Mr. Shyam Sundar Agarwal for this quick introduction. And also a warm welcome to Mr. Yoganand, who's just joined. I could see him a while ago on the video. So welcome to you, sir. And now I request our moderator, Mr. Vinay Thyagaraj, Chartered Accountant, Bangalore, to please start the panel discussion. Over to you, sir.
Thank you. Good morning to all. Hope I'm audible.
Yeah.
Yeah, thank you. Okay, good morning to all, and my special thanks to TCCI for having this program and open to public at large. I congratulate the organizers for this. I'm sure that Ms. Ankita has taken a much effort in terms of reaching everybody and make it a point that it will be on and it would be delivered the way it is designed. Thank you so much for TCCI and all the panelists, and also our Shekhar Reddy Garu and Bhaskar Reddy Garu, and also a President Ramakanta Saru and Prem Kumar sir. And I met most of them in person in Hyderabad. And I'm regular visitor to Hyderabad, and I'm part of the Telangana Builders Federation. I'm a regular speaker in most of the sessions at Telangana RERA. And it's my privilege to moderate this entire session. And we have very dynamic, efficient, effective, powerful speakers in today's session. Mr. Nipun Singhvi from Ahmadabad and Chartered Accountant Mahadev Birla. And to their credit, their various decisions and also various precedents they already set in their own states. And I'm sure that their knowledge and their practice makes a very much difference to our Telangana builders also. I welcome both of them for today's session. And also we have Mr. Vishnu Vardhan Raju Garu, retired district registrar. I requested him, I had a call on with him to speak on a couple of issues which is very much relevant as part of RERA. Of course, which was also there prior to RERA under apartment association, like how to form the resident welfare association, which is a preferred act or statute which is required to be implemented by the promoters or the builders, and also how the state government should give the respective GOs to follow it in compliance with the RERA. And second is about section 17 of RERA mandates entire common area of the project land should be transferred to the association of allottees. The moment we say common area, which includes the entire project land. So how do we do it? How do we do it? At this point of time in the southern state, we have a practice of transferring the undivided share of land to the customers or the buyers. But RERA is opposite to that. So how do we do, and what should be the industry call on it? How the government will react, and what would be the way forward for this? Because the act is mandated, and how do we implement it? So this is a very important things to be addressed. So we requested Mr. Vishnuvardhan Raju to be part of today's panel discussion to address these things also, sir. And as Mr. Shekhar Reddy Garu has mentioned about a few inputs about GST, yes, very much, which is of a burning thing, which has to be clarified by the government of India. And of course, at the right, with the right leadership under CREDAI and NAREDCO and other various builders association can represent and make it possible, sir. And project funding, as you mentioned, rate of interest is it's like getting at a lower rate is always depends on the credibility and the credit worthiness and also the collateral guarantee of the builders and the promoters. Obviously, it's a long way to go for in India in terms of getting a very low fund and very cost-effective fund, wherein the benefit can be passed on to the customers at the end of the day. So next is about designated bank account. Section 32 has a inbuilt power which is given to the RERA authority that can be given, and much more power is given under section 32 of the act, where the authority can recommend various recommendations to the government for the purpose of real estate. The power is so much which is vested with the authority, like RBI is for the purpose of banks, SEBI for the purpose of investment. I feel always RERA is for the real estate sector itself. However, we are just only 3 years of implementation, and in Telangana it's just a 2 years of implementation. I'm sure that the days to come, it will shape up very much in the interest of the promoters, in the interest of the industry, in the interest of the home buyers, and all the stakeholders. Will maybe down the line 3 to 5 years will the various doubts or various questions and various practices which are scattered in this industry would consolidate and will come out with the best practices, which may be equivalent to GO 86, which we are aware of it. So with this, my introductory remarks, and also about the as a moderator, the session is like Mr. Nipun Singhvi and Mahadev Birla will be presenting their topic, presenting their technical papers, and I'll invite them to present the papers. In between, I may be posing some of the question on behalf of all the promoters, which is very relevant to the Telangana and Telangana practice. And also any other questions can be posted in the chat. I can take it from the chat and I can post it to the, I can consolidate and I can post to the presenters of the day, speakers of the day. And finally, we'll invite Mr. Vardhan Raju to share his views and ideas about the association and the conveyance of land to the association, sir. So with this, I'll request Mr. Nipun Singhvi, sir, to go ahead, and Mahadev Birla, sir, to go ahead and start their presentation. Once again, thank you, FTCCI, for hosting this program. Mahadev, sir.
Yes, Nipunji is going to start
the session. Yes, sir.
Yes.
Can I have organizer to give a screen share to Mr. Nipun, sir?
It's given, I think.
Yeah, thank you.
So thank you, FTCCI, and special thanks to Mr. Abhay Jain for inviting us all the way. So we have got a chance to virtually visit the Hyderabad. So that's good, but we would always think of coming it physically when the things get normal. And it's very, I'm very happy to be a part of this discussion, because we have always had a chance to present it where the act has been functioning in full-fledged manner. But here it is a developing law. So I think that it would be very interesting for us to see what direction we can give on this law. So thank you, everyone. And I would just cut short the thanks note and start with the session so that we can utilize the best of our technical expertise here. So friends, basically, this particular law is a very interesting law. And I would just like to give you a brief background, what type of a law it is from the perspective of what would be the enforceability and who would be responsible actually for this law. So just to take you to the history, how this law evolved. This law, though it is a central law, it's a law which has been passed by the parliament, but we all are aware that the real estate per se is a subject which is of a state. It is not of a union. So basically, union, when they thought of bringing a law in this unorganized sector, they thought that we would bring a law which would be a formal law for all the states across India. So for all the states across India, they would have a uniform law, and that would be implemented by the relevant state. So they brought this law by way of a bill, placed it before parliament. But this particular complicacy came before everybody, that whether central government can make a law which will have to be implemented by state. So they sent this particular thing to Attorney General for legal opinion, whether it can be done or not. And interestingly, he upheld that yes, parliament can do it, and you can go ahead, make a law and ask all the states to make implementation of this law by making rules and regulations under the act. Now, there is a very, very interesting issue that all the states have not adopted RERA law. In fact, you would be surprised to know that this is not there in the state of West Bengal. West Bengal has its own RERA law. They don't have RERA Act. They had made their own West Bengal Investment in Real Estate Act, something WEBI-RERA. So the authority to make law is actually with the state. Majority of the states have adopted the central law and now they are implementing the law. So this is a very interesting issue that though the act has been made by the parliament, it is ultimately for the state. So as Mr. Reddy was saying that whether we need a new law or not, it's up to the state. So yes, it is absolutely up to the state to accept the law, implement it by way of rules or regulations, or make their own law. However, the issue of West Bengal is pending in Supreme Court for last 3 years. Still there is no order, and I think that ultimately it would be the authority of the state that will be taking care whether to go for a law or not. So that is one of the controversies which I just wanted to highlight, that any state can make their own law with respect to subjects which fall under the state list as per the Constitution of India. Now, this particular law, though it came in 2016, and there was a timeline that everybody has to implement by 2017, many of the states could not actually implement it with that effective date. And most of the states were falling behind the deadline of 2017. So basically, when this law came, it was that within a year, everybody would have to implement this law. But many of the states, like including Telangana, they have, I think, implemented only in 2018. So therefore, there was a time lag. So I would say that this law was a recommendatory law which had to be accepted and adopted by the state. So that is another thing, that the effective date of this law is not the same across states. So there are different dates for different states when they actually came up with this effective law. So this is how the journey of the law came. So you could understand when somebody contemplates that we need to bring a law, it takes almost, probably I would say, it takes almost 8 to 10 years in India to make it happen. So this 2009, when this law was a model law, and when in 2016 it actually came, it almost took 7 years to come into force. And that too, as we are learning that in many states, it is still being implemented. Now, interesting part is this law was with the intention of bringing the residential property into the ambit. However, during this deliberations and discussions in the parliamentary committees, this changed from residential to commercial also. So now, as of today, I have seen this as a misnomer, I would say, as a wrong notion prevailing in the minds of public, that this law is only to regulate the home buyers. This is not the case. It regulates residential as well as the commercial projects, as well as the commercial property. So there is no concept that it is only for residential or for home buyers. It is also for shopkeepers. In fact, recently I was handling a case where the properties which are in the mall, so there is a big shopping mall and there are different shops allotted. So those all shopkeepers are also allotted under the RERA law. So this is the beauty of this law, that it is one law which is now encompassing all the properties, all the immovable property under its ambit. And secondly, I think Mr. Reddy referred to this law as a law which is a prospective law. It's not a retrospective law. But interestingly, we will discuss that this law is not absolute prospective, not absolute retrospective, but it is retroactive in nature. So it's something more than prospective, but something less than retrospective. That's what the Supreme Court and High Court have held, that this law would be for the purpose it is enacted. So even if there is a project which is outside the RERA law, it was not required to be registered under RERA law on 2017, the effective date. Then also, it can be covered under RERA law for the persons who are aggrieved by the maybe the XYZ conduct of the developer or builder, whoever is the case may be. So as of now, the status, this is the latest status as per the Ministry of Urban Development. I'm talking about the central ministry because they have made a central advisory committee which meets on a quarter-to-quarter basis and gives suggestions to different states how to implement the law in a better way. So this is the status of the RERA law. how many states have still not notified, how many states have still are in the process of implementing. And secondly, you can see on the right hand side that the RERA authority, so under the law, there has to be an authority, just like Mr. Tyagarajan told that there is RBI, SEBI, all these regulatory authorities. Similarly, under RERA law, there has to be an authority. Now you can see 30 states, they have set up an authority, out of which only 25 are regular. So 5 are interim authority. In the case of Telangana also, it's an interim authority. It's not a permanent authority. Once it's under process, 5 states are still not set up. So point is, the law has not got a full-fledged implementation as of now. Can the state go with the interim authority? So answer is no. So that also we will discuss, that Supreme Court had said in 2019 that within 6 months, all the states across India have to have a permanent authority. So basically, Telangana still does not have a permanent authority. And therefore, if somebody decides, he can directly go to Supreme Court and file a contempt petition. So that is happening in some of the states in which I am aware, that if a state has not formed a permanent authority, it's a breach of law, because it's a Supreme Court judgment that every state has to make a permanent authority and a tribunal. So we would be discussing what is authority, what is tribunal, but broadly, this is the status as of now. This is the status of all the projects registered across India, how many agents are being registered, and what are the nature of complaints that have been disposed of. So we would be taking you through a journey of how the projects get registered. And it's not only a law which is beneficiary for the buyers, it is equally beneficial for the promoters, the builders, and the developers. In fact, recently in the last week, I had read that there is a very interesting judgment by Maharashtra RERA authority that the buyers who were not paying for the property, they had already executed an agreement to sell, but they were not paying for the sale deed. Authority gave a direction that yes, you make up the payment and then the sale deed would be executed. So it is not a case that the buyers cannot be penalized or directed. So this law is a balanced law. Balance in the sense for the builder as well as the buyer. So it has penal consequences for both of them if they do not discharge their obligations, and they both have rights to go before the authority. Broadly speaking, we would be discussing the important sections, rules, and regulations. Broadly, this act has 10 chapters, so it is divided into 10 buckets, I can say. There are 92 sections, out of which we would today be trying to cover almost 35 to 40% of the sections which are important. Important from the point of view of a user. So here we have a mixed audience, so we would be trying to cover all those sections which are important from the perspective of maybe the user, who is a consumer, maybe the builder, maybe the developer. And interestingly, Mr. Reddy also referred to that it is a law for consumer. So we will also take this interesting question that whether if I am a consumer and I am also a buyer in the property, can I go to consumer court as well as to the RERA court to get my grievance resolved? So answer is yes, we can go, but there are some conditions, some restrictions which we would be covering. And to start with, we would be taking the definitions. So Mr. Birla would go ahead with the definitions to tell you what are the nuances and what does a particular word mean under law, under RERA law, which otherwise we may be having a different connotation. So Mr. Birla, over to you for definitions.
Yeah, thank you, Nipunji. And once again, thank you to FTCCI for inviting us and sharing our views on this topic, RERA. Thank you to Vinayji, Abhayji, and everyone. Now, Nipunji and Vinayji has already explained something about background and why this RERA is there. So now I will take this basic object of this RERA, because I know a lot of people are there from the real estate industry. So the main problems were there regarding that some industry, not only in a particular one state, all over across the India, there were some problems that were facing by the promoter as well as or the customer also. So to regulate this real estate sector, the RERA has come. So there was a problem in respect of the transparency, diversion of the money, land title, incomplete projection, problem. So to regulate this problem, the RERA has came into the picture. So in 2016, the RERA has came with the main four objects: regulation of the real estate sector, protection of the interest of the consumer in a real estate sector, and then after transparency and establishment of the regulatory authority. Nipunji, can you stop the screen sharing? I will share the screen.
Yeah. Sharing the screen?
Yeah, I'll share the screen. Is it visible?
Visible.
So these were the main four objects of the RERA. I'm not going into the detail because we have a very short time with us. So I will not go into the detail of this object of the RERA. But there were four main objects behind this RERA Act. So these were the main four objects: to regulate the real estate sector, transparency into the real estate business, protection of the home buyer, and establishment of the regulatory authority. These were the main four objects behind this RERA. Now, to understand this RERA law, we can say there are three buckets. One is the builder. Three B's are there of this RERA: builder, buyer, and the broker. Because this is not only applicable to the real estate developer, this is applicable to real estate agent as well as home buyer. That is, we can say, allotee into the project. So there are three buckets of the RERA. And if we understand this law, then we can say what is applicable to the builder, what is applicable to the buyer, and what is applicable to the broker. So builder, we have to do this registration part, compliance part, some duties are there. Even promoter, real estate developer has a right also. We'll discuss that part also. Buyers has some their duty. They have to be aware some things which they are going before the booking of this any unit into the project. Then after, how to take a possession. Broker, they have to register with the RERA and they have to follow some function also. They have to comply with some duties also. So these are the main basic part of the builder, buyer, and broker. Now we'll understand some definition into the RERA. So main important part is the allotee. Who is the allotee? Generally, whenever we talk about the RERA or whenever we talk about the real estate sector, we always say this is the home buyer, home buyer, home buyer. But Nipunji has already told you that when this journey was started, this RERA, earlier it was applicable for the home buyer, but later on when finally RERA came into the picture, this covered the not only residential project, it's covered the commercial also. So as per the definition of the allotee into the real estate project, means the person to whom a plot, apartment, building, as the case may be, allotted, sold, or otherwise transferred by the promoter, and includes the person who subsequently acquire the property or the allotment through sale, transfer, or otherwise. So if we analyze this definition of the RERA, see, there are two types of the buyer. First buyer, who is directly buying the property from the real estate developer, and the second buyer who buys the property from the first allotee. So that the second buyer also cover under the definition of the allotee. And this second buyer has a very important role, or we can say he has an important right under the section 14(3) of the RERA. This talks about the structure defect. Now, what is the otherwise transfer? Suppose today the property is transferred by the to the legal heir of the will cover as a allotee, and that will also considered as a allotee. So otherwise transferred is also considered, and that is considered for this definition of the allotee. Now, whether the lessee is covered, the person when he is not transferring the property and the property is giving on the lease, whether that lessee will the cover or not, that is also there. And the one of the landmark judgment of the Bombay High Court is there, where it is upheld that the lessee will also falls under the definition of the allot. However, the tenant who takes the property on the rent, he is not covered under the definition of the allot. What is the apartment? So the definition of the apartment says apartment, whether called block, chamber, dwelling units, flat, office, showroom, shop, godown, premises, suite, tenements, unit, or by other name means a separate and self-contained part of any movable property. So the friends, here important thing is that apartments cover everything, whether it is residential, whether it is commercial, shop, showroom, godowns, everything. Again, I'm not going to read the entire definition, but the important crux of this definition is that there is no difference between there is no bifurcation between the residential and commercial. All, whether it is residential or whether it is a commercial, that will fall under the definition of the apartment. Now this advertisement has a very important definition, because as per the section 3 of the RERA, the promoter cannot advertise, promoter cannot make a sale, cannot book a unit unless and until the project is registered. Another important part of that, various state authority has prescribed their own guidelines that how advertisement would be happen. Even in the RERA Act also, that says then when there is an advertisement, that advertisement should mention the RERA registration number of the project along with the website of name of the authority. So advertisement is what? Even the advertisement, if I am doing a mouth publicity also, that is also called the advertisement. Even I am sending the message for an advertisement of any project, that will fall under the definition of the advertisement. So any promoter who is doing any kind of advertisement or promotion of the project, he should be aware that he is not violating the provision of the RERA. So advertisement means any document described or issued as an advertisement through any medium and includes any notice, circular or other document or publicity in any form informing person about a real estate project or offering for sale of a plot, building or apartment, or inviting person to purchase in any manner such plot, building or apartment, or to make an advance or deposit for such purpose. So this advertisement definition is very broad. It has covered everything, even SMS, emails, everything is covered under the definition of the advertisement. Now, this is the part of common area. I think we have a senior panelist here, Mr. Vishnu Vardhan, and that he will also cover when section 17(1) we will discuss under the RERA. So what is the common area? Because when any customer we have seen across the India, lot of the allottees file the complaint on the ground of the common area, and when the common area is to be handed over, and what falls under the definition of the common area is very important to understand. Because when the possession of the particular unit is given, sometimes allottee asks what's about the common facilities like children, play area, garden, clubhouse, gyms, everything. So whether it is to be handed over at the time of the unit is given or it is a later part. So it is very important to understand the definition of the common area. So briefly, I will go through this. In short, I will go through with this definition of the common area. So this common area includes the entire land of the real estate project, staircase, and lift lobbies, fire escape and common entrance, common basement, terrace park, play area, open parking area, and common storage, accommodation for watch and ward stops, installation of the central services, water tank, sumps, motor fans, compressor. These are the area falls under the definition of the common area. So common areas to be handed over as per the section 17(1) of the RERA, not at the time of giving the possession, because lot of allottees in the various projects, they file the complaint that once the project, the unit in the project is handed over, they should be handed over the common area also. However, RERA says that you have to file a declaration that during what period you will cover or complete this project. So what is the completion date of the project? On or before that date, even the RERA Act says that some time period is there. In that time period, you have to hand over the common area. But some states have defined that you fix the timeline to complete the project, which will cover everything, like handing over the common area, handing over the unit, conveyance of the unit, everything would cover. So the common area will be handed over at the time of after the completion of the project. Now, important thing is that what is the real estate project? So generally we say that when we are going to construct any building, whether it is residential or commercial, whether this will fall under the definition of the real estate project or not. But the important part is there, real estate project would be considered, how the real estate project would be considered for the purpose of the RERA. So 4 parts is there: development of the building, converting an existing building or part thereof into apartment, development of land into plots or apartment. But important thing is that that project should be available for the sale. Suppose today I am going to construct or I am going to develop a project, but I am not going to sell any unit into the project, then it is not required to be registered under the RERA, because that will not fall under the definition of the real estate project for the purpose of the RERA. However, once the promoter wants to sell as per the RERA Act, he has to register the project. But suppose I am today giving all the units into the project, whether it's commercial or residential, for the purpose of the rent, then it is not required to be registered. So this is the definition of the real estate project. I am not going to read this entire definition. Now, this is the very important thing is that what is the carpet area? Carpet area means net usable floor area of an apartment. So friends, again I'm speaking this net usable floor area of apartment, excluding the area covered by external walls, areas under the service staffs, exclusive balcony or veranda area, and exclusive open terrace area, but includes the area covered by the internal partition wall of the apartment. So net usable only, net usable area will be considered as a carpet area. And as per the RERA, earlier there were a practice that some developer used to sell the unit on the basis of the carpet area, built up area, super built up area. So there was some margin. Now RERA has come with the unique measurement that every promoter will sell the unit on the basis of the carpet area. Now friends, practically how can we understand this carpet area? I will explain. Now this is the picture of or we can say this picture of the particular commercial unit. So if you see the whatever the inside area is there, this is the open terrace area which is highlighted, and this is the area where the these red lines are there, that will fall under the definition of the carpet area. Now whatever the external wall is there, that is highlighted by this purple color, that will not be covered under the carpet area. For the better understanding, we'll understand this by way of the example of this residential unit. So again, here whatever the purple lines are there, boundary are there, that is the external wall. So that will not be the part of the common area, right? Now this green color is there, that green color boundary is there, that is the internal wall. So that will cover under the definition of the carpet area. Now whatever the balcony and veranda area is there, that will not be part of the carpet area. And whatever the inside net usable area is there, that would be considered as a carpet area. Now important thing is that here in the Telangana state, they have defined the definition of the sellable area also. And into the draft agreement also, they have said that the promoter can write the carpet area also, and they can write the sellable area. And this definition covers that sellable area includes the carpet area plus veranda, balcony, terrace area, which are exclusively meant for the allotee, plus proportionate share of the common area also, and other area as agreed between the promoter and allotee in the agreement for sale, for which the proportionate cost has been collected from the allotee. We will discuss this during the transfer of the title also, section 17(1), because this sellable area covers the proportionate share of the common area also. However, in some state there is a practice that once the unit is transferred, they mention in the agreement to sale or the conveyance deed that the common area is also transferred to the allot, because they are not going to, or they are not going to make a separate conveyance deed for the land of the project, because again there will be issue of the double stamp duty, because the stamp duty will also be paid at the time of conveyance deed of the individual unit, and again the stamp duty has to be paid for the transferring of the land of the project. So some states there is a practice that when they are making a conveyance deed of the individual unit, they write into that sale deed that conveyance or this proportionate common area is also transferred along with the particular unit, and they hand over the society to the allotee or association of the allotee, and they form a society that is called the service maintenance society. Now this is the definition of the promoter. So this is a very wide definition. Here will be the major issue. I think Vinay will share his view also, and we'll discuss that part also, whether the landowner is considered as a promoter or not. Some states, some very landmark judgments are there when it is held that the landowner is also considered as a co-promoter into the project, and he is also equally liable for the all the responsibility as far as the RERA Act is concerned. So developer plus the landowner, when the project is developed by the one developer where the land is given by way of the development agreement. So in these cases, the land developer as well as the developer who is the promoter is equally liable for the all responsibility as far as RERA is concerned. Real estate agent, in short, we can say real estate agent is a mediator who facilitates the sale, and he makes this happening of the sales between the promoter and the allotee. So I am not going to read the entire definition because it is already 12:30. Now this is a very again important definition which is prescribed by the Telangana RERA, which talks about the structure defect. So it is clause 12 of the agreement to sale. It is mentioned that notwithstanding anything contained in the above clause, the structure defect will exclude these things. And what is the excluded from the structure defect is that equipment, that is lifts, generator, motor, STP transformer, gym equipment, which is carry manufacturer's guarantee for a limited period. Thereafter, the welfare association society shall take annual maintenance contract with the supplier. The promoter shall transfer manufacturer warranties to the allotee or association of allotee as the case may be. Fitting related to plumbing, sanitary, electrical hardware, etc. Allowable structure and other deformation including expansion quotation. The terms of the work like painting, etc. So these are excluded from the definition of the structure defect, because an allotee can file an application or a complaint before the RERA authority for a compensation when there is a structure defect in the particular unit, and the allotee has the right till the 5 years after he gets the possession of the unit. So this is a very important definition as far as the structure defect is concerned. Now in short, quickly I will cover this applicability of the RERA. Before that, if there is a question, we can discuss, Vinay ji, or should I move further?
Sir, you can move forward.
Yeah, because I think it is already 12:30. That's why.
Yes, sir. Please go forward. At the end, we'll take the questions, sir. Okay.
Yeah, Nipun ji, your views, anything related to this topic, so we can also. Should we move? Okay. So now,
Mahadev sir, one question always which is exists with the promoters and also the larger group that you have to address along with this registration. That is specifically, I take the occupancy certificate. I use only my funds, and I will not pre-launch. I don't market. I don't collect the money from anybody. Still, do I need a RERA registration? So that is the one thing. Along with this section 3, please cover that also, sir.
Yeah, we'll discuss. If anything miss out, we can have a discussion on that.
Yes, sir.
Right. So now I'm going to explain the provision of the RERA. What RERA says. RERA says section 3, that is the applicability. We can say that the project, whether it is registered or not. If the project is registered with the RERA, so section 3 bars, or it puts the restriction on the promoter that unless and until you register the project with the RERA, you cannot do sale and booking into the project. You cannot invite any person. You cannot do any advertisement. So what Vinayji told, this is a pre-launch. So pre-launch is considered as an advertisement, and section 3 restrict and bar that promoter cannot do the pre-launching unless and until the project is registered, because clearly it is mentioned that no invitation, no kind of any document, nothing can be say by way of advertisement which say that you are going to launch it or you are going to come up with the project. Even in the some states, even I talk about the Gujarat also, sometimes promoter do not make any launching. They only just put a signboard on the land of the project. Yeah, Vinayji, you want to say something? Vinayji, any question?
No, sir, your voice is not audible. You can continue now.
Yeah. So the thing is that how this pre-launching can be, whether it is restricted or not, whether it should be happen or not. So as far as RERA is concerned, even the Gujarat state, we have seen some promoter put a signboard of the project saying XYZ project coming soon. Now, whether this is considered as an advertisement or not. So yes, it is considered as an advertisement, and the RERA authority has even imposed a penalty on for particular this type of advertisement also. So as far as your question is concerned, whether the pre-launching should be done or whether it should not be. So according to my view, this as far as RERA Act is concerned, you cannot do any type of advertisement, including the pre-launching. Now, what RERA says that the project which is ongoing as on 1st May 2017 and for which completion certificate has been received, that project is not required to be registered under the RERA. The project which is ongoing as on 1st May 2017 and for which the completion certificate is not received, that project is required to be registered under the RERA. And every project which is launched after 1st May 2017, or we can say which is for which developer permission has been received after 1st May 2017, that every project is required to be registered under the RERA. Now some exceptions are there. When the project land size is less than or equal 500 square meter, or the number of unit in the project is less than or equal to 8, that project is not required to be registered under the RERA. Another important thing, when the real estate project is not available for sale, that project is also not required to be registered under the RERA. Sometimes many promoter or the professional ask the question, so today suppose I make a project and I develop the project, complete the project, and I receive the occupancy certificate and building use permission. Whether after that can I sell the project, or whether after that is it required to register the project under the RERA? So they say sometimes they feel that project is not required to register, but this is the wrong perception. Even you have received the occupancy certificate, but this occupancy certificate, we have to see whether it is received after 1st May 2017 or before 1st May 2017. If it is received after 1st May 2017 and you are going to sell the project, then RERA is required, that registration is required under RERA. This is the definition of the section 3. I am not going to read in detail because I have already explained the exception also and what is the restricted under the RERA and section 3. Now the important thing is that the Telangana state rule defines the definition of the ongoing project. According to my view, this definition is little bit contradictory to the act. So I am going to read this. Ongoing project means a project where development is going on and for which occupancy certificate or completion certificate has not been issued, but exclude such project for which building permission were approved prior to 1st May 2017. So now what this Telangana state RERA rule says that once if the building permission is received before 1st January 2017, that project will not fall under the definition of the ongoing project. So according to my view, this cannot be happen because RERA says you have to see only one thing, whether as on 1st May 2017 project has received the completion certificate or not. If project has not received the completion certificate, that project is considered as an ongoing project and that is required to be registered under the RERA. So this definition may create some litigation in the future because this is in contradictory to the provision of the Act. Now, another important thing is that Rule 4.1 of the Telangana state says, upon the notification of the commencement of subsection 1 of section 3 of the Act or the commencement of these regulations, whichever is later, the promoter of an ongoing project who has not received the completion certificate shall within the time specified in the subsection make an application. So this rule, according to my view, again is in a contradictory because section 3 talks about that ongoing project has to make an application for the registration within 3 months. But suppose this rules has notified later on, so this is again overriding or it is beyond the provision of the Act. Now, registration part is that any promoter has to do the online registration. Project registration is required. What important documents and information they have to provide? They have to provide the details of the promoter type, PAN number, address, mobile number, project detail, project agent detail, architect detail, structure engineer detail, project contractor detail, registration certificates, architect, engineer and CA certificates, financial statements, income tax return copies, encumbrances certificate, commencement certificate, plan copy, land document, title reports, and declaration by the promoter. So that declaration is RERA rule. Telangana state has defined the Form B is the declaration where we declare that there is no loan or whether loan is there or not, how within how much time the project would be completed, about the title also. As per section 4.2L, some declarations are there that is to be given under this Form B. Now, when we talk about the registration, the fees is that it is on the basis of the land area, and there are 4 categories of the project under the Telangana state: group housing project, mixed development, that is residential or commercial, only commercial project, and the plotted project. So fees is defined on the basis of the land area. So when the land area is less than 1000 square meter, in case of the group housing project, fees would be 5 rupees per square meter. When the land area is greater than 1000 square meter, the fees would be 10 rupees per square meter, subject to 5 lakh rupees maximum. In case of the mixed development project, it is 10 rupees per square meter when the land area is lesser than 1000 square meter. In case of the area is more than 1000 square meter, the fees would be 15 rupees per square meter, maximum 7 lakh rupees. In case of the commercial project, again it is 20 rupees per square meter, and when the land area is more than 1000 square meter, it would be 25 rupees, maximum 10 lakh. Or in case of the plotted development, there is no cap for the area. It is 5 rupees per square meter, maximum rupees 2 lakh. Now, what is the declaration and what is the problems were there when the real estate RERA, this RERA Act was not there? Some problems were there regarding the title of the property, delay in the possession, and diversion of the money, approval, and something problems were there. To sort it out this problem, what RERA Act says that promoter, when he's filing an application for the registration, he has to give some declaration. Declaration is that undertaking for the clear title of the property. That is defined under the section 4.2LA. Undertaking that land is free from the encumbrances. Undertaking that the project would be completed on so and so time, whatever the time period they want to decide. However, in the Telangana state rule, I think one rule is there. I will discuss that also, and that is given for the extension of the project. That when you are getting a commencement certificate for construction of the project, it talks about some particular time period, and within that time period you have to complete the project. And the Telangana state rule says that the extension of the project which will not be granted beyond that time period. So that is a very interesting and contradictory point that I will explain you practically also how it can be according to my view. So what undertaking they have to give diversion of the money, that promoter has to deposit 70% of the money into the separate bank account. I think Mr. Reddy were discussing about this point also, whether it is escrow account or a separate bank account. We'll discuss that also. Another declaration promoter has to give that whatever the approval is there in respect of the project, that would be given whenever they receive. Some approvals are required before the registration of the project. Some approval may be required during the construction phase of the project. So undertaking has to give that all the permission, all the certificate register requirement they have received, they have to give to the RERA authority. This is the financial discipline under the RERA. RERA says that promoter has to deposit 70% of the money amounts realized for the real estate project from the allotee from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of construction and the land cost, and shall be used only for that purpose, provided that promoter shall withdraw the amount from the separate account to cover the cost of the project. So this is the very important part, because earlier there used to be diversion of the fund, but now to restrict and to complete the project on time, they have specifically mentioned this provision where the money will be deposited in a separate account, and this is not an escrow account. So whenever any banks or any RERA authorities ask about the escrow account, that is not the correct or legal thing, because they talks about the normal current account, which is to be required to be opened for the purpose of the RERA. Again, to withdraw the money from that separate account, every promoter has to get a certificate from the engineer, architect, and a chartered accountant. Apart from that, every promoter has to file a statement of account, annual statement of account in respect of the every project. Again, the important thing is that this is requirement is in terms of the project. Suppose a partnership firm having more than one project, so they have to file a separate statement, annual statement of account for particular project, not for the partnership firm. Now, application has to make registration to be granted within 30 days. If there is no registration is granted within 30 days, then obviously that would be a deemed registration. This is the registration requirement in case of the agent. I am not going to this now. This is the important section. Then after I will hand over to the Nipunji, because it is already 12:40. So what section 11 talks about? This talks about some duties of the promoter. What are the duties of the promoter? That promoter has to quarterly update the information in respect of the project. What information they have to update? Booking status, project status, detail of the approval taken, detail of the registration. Again, there are some duties of the promoter. Maintenance of the essential services in the project unless and until the project is handed over to the association of allotee. Payment of the all outgoing charges. That promoter cannot, promoter has to make the payment in respect of the loan, interest, whatever the this electricity charges, whatever the local authority charges are there, that promoter has to make. Apart from that, promoter cannot make a unilateral cancellation of the any unit in the project. If it is made, the customer can file a complaint before the RERA authority. Now, important part is that section 13 is there. Section 13 talks about that when the 10% of the money is received in respect of the any particular unit in a project, the promoter has to execute a registered agreement to sale, and that format is defined under the Telangana state rules. 38 rules, rule number 38 define the format of the agreement to sell. Now, important thing is that in the clause 7.5 of the this agreement to sell, cancellation by the allotee, it is stated there that once the allotee cancel, he is not willing to keep the unit into the project and there is no fault of the promoter for that part, then if he want to cancel the unit, then it is mentioned that the promoter will pay the money after deducting the charges within 3 months of the such cancellation, or at the time that promoter is able to resell the said apartment, plot, or another purchase, whichever is later. So this is again the very contradictory point, because then how the person will file application under the section 18 of the RERA, that we will have some 2-3 minutes panel discussion with Nipunji and Vinayji, right? This is the part of structure defect. Structure defect said that in case of any structure defect in the unit, customer can file a complaint and he can seek a compensation. Now, what is the time period to, for this structure defect is that 5 years from the date of the possession. So suppose today I get a possession on the 17th October, and suppose next month another customer get the possession, So 5 will be counted individually for the every customer. For me, it will be counted from the 17th October. For the another customer, it will be counted from the next month when he gets the possession. So it is not linked with the date of sale deed. It is not linked with the completion date of the project. Neither it is linked with any agreement to sale date. It is only start from the date of the possession. It is clearly mentioned, and it is the duty of the promoter to rectify that structure defect without any cost, and that has to be rectified within 30 days from the date of the intimation. Return an amount of the compensation when any promoter fails to complete the project and give the possession of the unit as per the agreement to sale, and the customer wants to get a refund, he wants to cancel because of the non-fulfillment of the promise of the promoter, then he can go for the cancellation and he can seek a refund along with the interest and compensation. Apart from that, he can withdraw from the project also, and if he is not intended to withdraw from the project, he can seek an interest for the delay. This is the section it talks about. Rate of interest is MCLR plus 2%. In the Telangana state, timeline is defined as a 90 days. Some rights of the allottees are there. They can take a possession within the time, stage by time schedule of the project, refund of the amount. So this is from my side because we have very lesser time, I think. So now this is to Nipunji. He will explain some legal aspects. Then we can have a question answer on that everything.
Thank you, Mahadev, for your presentation. Thank you so much. And as I mentioned, we'll take the question and answer at the end of the session collectively. Nipunji, please go ahead with your presentation, sir, on the legal aspect and under RERA.
I think it is visible now, Thyagaraj ji.
Yes, sir. You are perfectly visible, sir.
Okay. So I think the rights obligations have been covered by Mahadev ji. Now the next step for the person who is actually aggrieved by any of the rights or duties which have not been complied with. So he would be normally any aggrieved person who feels that he is aggrieved. Now this is very tricky situation. Who will be aggrieved? Now normally situation is that if I have bought something, I would be aggrieved. But as I have given an example, even the builder can be aggrieved. Second would be, in most of the RERA rules across states, they have identified the concept of association. So suppose there are some common facilities of particular project, then those facilities can be taken cognizance only by the association, because association of allottee is a structure who can object to the common facilities not given. So let's say there is a clubhouse, let's say there is a common parking, let's say there is a garden. All these issues can be taken care by the association of allottee. So even the allottee would represent all the allottees and file the complaint. So we'll be also discussing one of the case law on this on the last slide. And third is the voluntary consumer association. Now this is a concept which has been borrowed from Consumer Protection Act. So they can even go for a consumer association to file a complaint. So I will just skip that consumer association and focus on the major complainants under the law. So there could be broadly 4 types of complaint which would be going to adjudicating officer. So now let me tell you, there are 2 steps in the RERA law. One is the authority and another is the adjudicating officer. Now adjudicating officer is a judicial person. He is a retired district judge. So what they say is, they say that the adjudicating officer, who is a retired district judge, equivalent to a retired district judge, can only adjudicate the issue because he is a judicial person. So authority can determine that there is a non-compliance, but the adjudicating officer will decide what would be the amount of compensation to be paid to the aggrieved person. So there are mostly 4 types of issues before him. One is whatever has been promised in the advertisement is not delivered. So advertisement includes here the brochure, maybe whatever the marketing material he has used to induce the allottee to buy. So normally it happens that they have promised so many facilities, but actually when they are being delivered, out of 10 facility, only 4 are given. So that would be covered under section 12. Second would be structural defect, which as Madhevji has already explained, what would be the structural defect. So there would be structural defect time period of 5 years, and that is the limitation period for filing the complaint under structural defect. Third is, and the most important of the complaints is section 18, that is delay or failure to give possession. So delay or failure to give possession is under section 18. So if the possession is not delivered on time or is not delivered at all, then section 18 gets triggered. So section 18, I think I have found maximum complaints under section 18. And section 19 is, if there has to be, if the refund is triggered by the allottees, then it would be section 19. So these are the 4 broad categories under which complaints follow before the adjudicating officer. Now, except these 4, everything goes before the authority. So authority, by authority, I mean that the members sitting in the RERA authority. So normally there is a chairman, there is a secretary and other members appointed. However, in case of Telangana, I just saw that there is only a chairman and a secretary. So the other members are not there in the RERA authority. So as per the law, there has to be 2 members at least to hear the matter. Now, if the matters is not being heard by 2 members, a judicial challenge. So I would also take you to the judicial challenge which happened in the case of tribunal. But broadly speaking, everything other than those 4 issues which we have discussed will fall before RERA authority. So if agreement to sell is not done and payment is made more than 10% of the cost of the apartment or plot, whatever the case is, if the sale deed is not executed, as the law says, it has to be done within 90 days, or if something is mentioned in the local laws, it will go by that. If the possession has not been delivered on time, if there is a title defect, all these issues will go towards the complaint before the authority. Once the authority determines that there is a violation, then consequently all issues can be clubbed together for compensation. So broadly, complaints are mostly against the owner, the promoter, or the developer. If you see the broader structure of the law, it is against the promoters mostly section. But there is one section which I have told you, that if the money is not paid by the allottee in time and the sale deed has to be executed, then the complaint can be filed by the promoter, builder, developer, whoever is having the right to sell. So this is the broad categorization of the RERA authority. I have told you there has to be 2 members, and adjudicating officer, there has to be 1 retired district judge. So I will not go into much detail in RERA authority. Second issue is the RERA authority is taken as good as a civil court. So I think Mr. Vishnu, your mic is open. Can you mute it? So the powers which are there with the RERA authority are the powers given to it just like a civil court. So interestingly, they can issue summons to anybody to present before them. Now, I would just share a small case with you in which we appeared for a complainant who was not given the possession, who was not given the sale deed to execute. Now, in that case, we said that he has taken a funding from State Bank of India and the payment is 80% made. 20% will only be made when the draft deed is executed. Draft deed is shared with us. But the promoter failed to do it. Now, in this case, there was a dispute whether the State Bank has made the payment to the builder's account or not. So when he alleged that this particular payment has not come, RERA authority issued a summons to the State Bank of India manager who was responsible for that particular branch. And he appeared on oath, gave an affidavit that yes, this amount has been disbursed. So that is the way and the functioning of RERA authority, why RERA is working fantastically in contradiction with all other laws which were previously there is, they can exercise the power of a civil court. So they can summon, they can ask for any documents and can ask anything on affidavit. So whatever the power of a civil court is there, it can be exercised by RERA authority. Now, this authority or adjudicating officer complaint form is there, format is there. Now, here I have my own reservations being a lawyer. Whenever I see the law that gives a format of filing a complaint, I would say that a law cannot teach you how to draft a complaint, but the law can definitely tell you what minimum basic elements are there. So here the basic elements have been given, but to draft a complaint, it has to be something meticulous. Now, whenever a complaint is being filed, as we have discussed for AO, there are 4 sections under which a complaint can be filed for compensation. And for other issues, under authority, it is very important that the facts of the case are narrated in a manner which is substantiated by relevant evidence. So, for example, if your case is that the advertisement said 10 things and 6 things are delivered, so 4 things are not delivered, that you have to show by way of documentation. So there you need to annex all those in the facts of the case, referring to annexure so and so, so and so, and so and so. When it comes to relief, this I have seen from my personal experience that most of the complainants, they normally do not consult lawyers, obviously, because they think that they can represent themselves, and even the chartered accountants. So my suggestion is, whenever you want to ask for relief, there has to be 2 types of relief. One is interim relief and one is final relief. So let's say, for example, the example I discussed of State Bank of India. So we sought an interim relief that probably what would be the outcome, we don't know. But that particular flat may not be sold to anybody else. Till the sale deed is executed in my name and the matter is sub judice, this particular flat or apartment be sold, because the plea may be taken thereafter that the flat is already sold. Because you see, agreement to sell is not binding. Sale deed is binding. So until the conveyance is done and there is a complaint of delay possession or no possession at all, I suggest that always an interim relief should be asked. Without asking for interim relief, even if you win the case and finally that has been sold, you can only ask for damages. You cannot ask for specific performance of that contract for getting that particular immovable property. So that is an aspect which I just wanted to highlight. Then there is one interesting issue which in the beginning I told, that if there is a consumer complaint also, can I go for RERA complaint? So answer is yes and no. Why it is yes? Because if your complaint is falling, let's say in section 12, 14, 18 and 19, then you can withdraw the complaint from consumer and file it under RERA before the adjudicating officer. But if your complaint is not falling in 12, 14, 18 and 19, other than this also, you can prefer both the laws. You can prefer consumer law as well as you can prefer the RERA law. So you have 2 laws running parallelly. So the notion is wrong that the consumer law is outdated. You still have the rights under consumer law. Another example, let's say your structural defect is there and you are covered in that 5-year time period. You can go before RERA. But what about after that? If you come to know a defect which is beyond 5 years, you come to know, then consumer law is always there to help you. Now, after this adjudicating officer or authority, the appeal goes to one forum that is called appellate tribunal. So RERA appellate tribunal is there. I am not going to discuss the manner of filing and all, but conceptually, RERA appellate tribunal, you can say, is the last forum where your facts will be adjudicated. So always there is a 2 concept in any judicial proceeding. One is based on facts, another based on law. So factually, everything will be decided at this level at the last stage. So authority will decide, give a verdict, then an appeal can be filed before tribunal. They can also go into the fact, but after this tribunal, the remedy would be before High Court. There you cannot ask for adjudication of facts. There you can only go for question of law. So this is the difference, precise difference between a proceeding before quasi-judicial authority and before a completely judicial authority. Interesting issue in this particular appellate tribunal, I have been told that in the state of Telangana, there is no separate RERA appellate tribunal. And as Mr. Abhayji was telling, we had been successfully able to get a direction from Gujarat High Court in a PIL which was filed by me in my personal capacity, that the RERA appellate tribunal was not there. And I think it would be the fastest PIL to be disposed of. Within almost 8 months, we got the order by Gujarat High Court directing the state to make the formation of appellate tribunal, and they gave an undertaking that the process is in last stage and they would be implementing it soon. So what was happening there? The appellate tribunal was not there, and they had designated food safety appellate tribunal as RERA appellate tribunal. Now the issue was twofold. There was only one judge who was sitting in the RERA appellate tribunal, because in food safety tribunal there is only one single judge required. Secondly, in case of RERA appellate tribunal, there has to be two members. One has to be judicial and one has to be technical member. So we argued that this particular appellate tribunal is illegal because of various judgments of Supreme Court, that if a law provides two members should be there, there cannot be a single member. So on this ground, in fact, one PIL, we are also appearing in Rajasthan High Court, and it is also in final stages. So probably this would also come. So I would suggest the chamber to take up this cause in the state of Telangana. We can always go and prefer an PIL in the High Court and get a direction that state government may implement it and make it maybe in 2 months or 3 months. So that is my suggestion to the chamber here, that the representation should be made and even recourse to the PIL may be taken. This, I think I wanted to explain it in much detail, but due to time constraint, I will not go into very much detail. Broadly speaking, if you are aggrieved, I am talking about both the sides. Maybe it's the promoter side, maybe it's the lottee side. If he is aggrieved or she is aggrieved by the authority's order, then an appeal, when it is filed before tribunal, if there are no two judges sitting, you can very well say that I will not appear before it and directly go to High Court. Reason is, the law says if even any order is passed by a bench which has to have two judges and there is one judge, then the complete order is illegal. So if there is a law which says two member has to be there and single member is sitting, then that particular order and the legal proceedings become void ab initio. So I have quoted some of the judgments on this particular aspect. Two of the judgments are mine only, where I had appeared as a petitioner. So I suggest you to go and read these judgments, because this judgment has been upheld in RERA also. In fact, in GST tribunal also, we were the first one to challenge it, and that has also come in our favor. I would suggest that you may read these judgments, and these are very finer points, because normally I have seen whenever litigants or professionals appear before the forum, they don't see how many judges are sitting. And as a lawyer, the first thing which we see is how many judges are sitting. Because if the judges are not complete as per law, in my view, all the proceeding would be declared null and void subsequently. Then if there is a non-obedience of the order, see, there is a penalty, there is an imprisonment which is permitted in both the authority as well as the tribunal's order. If there is a non-obedience, mind it, see, they have the power of imprisonment. So it is a serious power. It's a civil imprisonment which can be ordered by the tribunal. So it has to be very cautious, because this law is in evolving state, and I am contemplating that maybe after 5 years or 10 years down the line, this will become very strict in terms of the regulatory environment. So it has to be taken very seriously that the non-obedience will tend to amount to contempt of court. So that is my view on this aspect. I would not go much into this. I think I will just skip up to the last aspect, whether RERA law can allow the civil court also to interfere. Answer is no. RERA says that if some grievance is there under RERA contract, this RERA Act rules and regulations, some contradiction is there, some breach is there, the relief can only go to RERA. Subsequent cause of action cannot be taken in civil court. So clearly, civil courts are barred to exercise their jurisdiction. So here the things cannot lie for 1 year or 2 year pending. So that is the beauty of this RERA law. And similar provisions have now come in almost all the laws which are becoming special laws. Then the last one, whether other laws are barred when RERA is applicable. So other laws are not barred when RERA is applicable. So how they are not barred? Like I told you the example of consumer protection law. So consumer law is parallel law, proceedings can go on. Same issue, both the law proceedings can go on. Civil code can come only when the issue is not covered under RERA law. For example, if some project is not registered under RERA and interpretation also comes that it is not required to be under the purview of RERA, then the breach could be alleged and gone to civil court. Because in RERA, they have agreement to sell deed, everything format is given. But before this, there was no format. So if there is a breach, you need to go to civil law. Third and most interesting issue is nowadays, because of the cash liquidity crunch, big developers, big real estate companies are going insolvent. They don't have money. So this particular contradiction went up to Supreme Court that whether a person who is a home buyer, can he trigger insolvency for the complete company? So maybe a company has 10 projects, 8 projects are completed, 2 projects are incomplete. So can one buyer of those 2 projects, which is incomplete, trigger insolvency for the complete company having 10 projects? So it has been answered by Supreme Court in positive in favor of the buyers, saying that insolvency can be triggered if there is a delinquency, non-payment by the owner. So therefore, IBC and RERA, if they contradict, IBC will prevail. So this is a very interesting issue. In case of consumer and RERA contradiction, both will prevail. But in case of IBC versus RERA, IBC will prevail. So broadly speaking, this is the concept of applicability of other laws. And lastly, this RERA law is a civil law. It is not a criminal law. So if there is a fraud, cheating, breach of trust, anything like this, criminal action can be taken, FIRs can be registered. So this law is a civil law. Don't mistake it with the criminal law. If you have a grievance in criminal law, you can very well go and take action under criminal law. So I think Mr. Vinay, I would pause at this and let's take the question and answer. I tried to cut short it.
Thank you, Nipunji, as presenting the entire gamut of legal under RERA. Of course, the time is not sufficient for us to present the entire and also a various decided case laws of various authorities and also the high courts. Now, in the interest of the time, I requested Sri Vishnu Raju Garu to unmute yourself and also request you to share some of your views and also the present practices at the state of Telangana with respect to registration of the resident. The reason is under the RERA, it's mandatory that promoter shall register the association of allottees once the 51% of the booking in the project is complete. So that's one thing, sir. We wanted you to address and also share your experience, knowledge on under which statute the Resident Welfare Association shall be registered in the state of Telangana, number 1. And the second question is about Section 17 under the RERA Act. It mandates entire common area of the project shall be conveyed and transferred and handed over to the association of allottees. That means to say I should have an association take the conveyance of the project common land, including the project land. So having said, we have a concept of undivided share transfer to the individual allottees all the way in the southern state of India. How do we address it? Or any efforts are made by the industry association or the state government to bring this in line or in compliance with the RERA Act, sir? Over to you, sir.
Sir, thank you very much. Thank you for FTCCI for giving me an opportunity to address you. And Nipun Singhvi ji, Abhay Kumar Jain, Mahadev Birla, Vinay Thyagaraj, and Khatya Nirvani and others, Yoganand Saab, Ramakant Inani, etc. So, sir, actually, the entire subject goes on with the RERA Act. RERA Act, it's actually, I'm not much aware of the RERA Act, but definitely, as you said and as you informed me, I am concerned about the Registration Act as well as the registration of the societies and everything. No problem. But you see, first of all, as Mr. Shekhar Reddy Garu said, the entire India, we have three things in the life: roti, kapda, or makan. So roti, kapda, it's not the subject of our people, but makan is the subject of our people. That means real estate people, real estate and developers. So real estate persons and developers, they are doing a very big service to the nation. All the governments, including central government and state governments, they are catering only 10% of the needs. That means they are able to provide only 10% of housing. The rest of 90% is being addressed by the real estate people and as well as developers. So why I am quoting this is, the government is totally depending on the real estate and developers on housing, but they are being deprived, they are being dishonored, they are being, as I say, I must say that they are being ignored in all respects. There were so many acts for implementation of this construction, real estate and everything. In each and every state, they have their own act. So they are doing according to the acts imposed by the states and their local acts. But RERA is such an act, it is covering all the entire nation, and it is addressed to each and every builder of the nation. Here my question is that almost all the provisions, in the 90% of the provisions of the RERA are almost there in the earlier acts, either by the state or in the central. So now few things are newly addressed in the RERA Act. First thing I wish to address about the formation of the association. Section 99 of the RERA Act mandates to form the association. Association is a must nowadays, because once it is just like, you see, it is an affair. Affair means don't think otherwise. It is an issue before marriage and after marriage. So once the property, the flat or apartment is transferred or conveyed to the purchaser, or whatever we call allottee. So from there, he is bound to follow certain common rules related to the unit or apartment, whatever it is. So here, a member or a group of members are invariably enforced or mandated to form an association of the allottees. So what is the duty of the association and what the association is meant for, that is another question. Actually, in Telangana and earlier combined Andhra Pradesh, 99% of the associations were used to be registered under Public Societies Registration Act. See, the Public Societies Registration Act is such a flexible act that it has no strong tentacles or strong binding on the members. The Public Societies Registration Act allows number of associations in a single apartment. It doesn't prevent, it has no power to prevent formation of a second association in the same unit. So that has led to so many problems, because a number of associations were used to be formed, and each and every fellow used to claim that he is their association is the main association, like that. So with that, what happened? So many complications were arised, and so many things are pending in the court for last so many years. And because of that, the development, the common welfare, and the addressing of a minimum, the smallest problem of that apartment is being had. So another thing, actually, another form of forming the association is under Cooperative Societies Act. I think it is prevalent in the state of Maharashtra. So the Cooperative Societies Act, it is a very tight act. Once the association is formed under Cooperative Societies Act. The members are bound to act as per certain rules and regulations of that act. They cannot go independently. The main thing is that they cannot, that apartment, or the group of LRTs cannot go for a second association. So that is one of the advantages in Cooperative Societies Act. So coming to the section 17 of the 16 of the Act, 16 of the RERA Act, promote, there are certain obligations to the promoter. He should first of all ensure the entire building or project and get the documents to the association. So here we can know the importance of the association. So suppose if there are 2 associations, 3 associations in a single unit, so what can a builder do? So here the RERA Act should specifically mention or specifically create some provision for the association, and which group of people should be recognized as association, or can the RERA allows all 2 or 3 associations? So it must be cleared through some amendment or something like that. Otherwise, RERA should specifically specify that all associations should be under Cooperative Societies Act. So after formation of the association will act as a government to the extent of that unit or association or apartment or a group of LRTs. So here two things again. Once association is formed, what is its responsibility? As far as the ongoing practice in both Telangana and Andhra Pradesh is concerned, it used to take care mainly the maintenance of the association. Maintenance includes lift, water, electricity, and like that. So there are certain other things. Nowadays, the apartments, the old type of apartment system has gone. Now the entire new type of apartments, new type of accommodation system has come up. So big apartments having clubhouses, swimming pools, recreation zones, etc. they have come up. So earlier, one thing was questioned and I was asked to give clarification on common areas. So as far as common areas are concerned, there are 2 types of common areas. One common areas are general common areas, as we were talking just now. Lifts, electricity, maintenance, all other things which are regularly useful and used by all the LRTs. Thus, another type of common area is they are named as limited common areas. It is defined under section 4 of the AP Apartment Acts. So as per the definition, these common areas are under the control of the builder or promoter. So builder or promoter will facilitate certain common areas like clubhouses, recreation zones, polo grounds, like that. So they are not the part of that apartment or unit. So in such cases, members are given an opportunity to use them, or they are allowed to use them on certain conditions. So all these things must be embodied in the agreement prior to conveying the property in the name of the LRT. So if the builder and the LRT is in agreement of using the common areas at cost or at free of cost, that must be there. That must be clearly mentioned in the agreement. So if it is not there in the agreement, it is sure that the LRTs are not entitled to use the second type of common areas, limited common areas, for their use. So the issue of common areas must also be addressed in the RERA Act. and it should be very clear which type of common areas are for the use of the allottees and which type of common areas are not for the use of the allottees. So here the association's role is to get clarification regarding this one. With the builder, the association comes into existence soon after the builder developer handovers the property to any one or two or few of the allottees. So once certain 10% or 20%, 30% allottees or flats are allotted to the members, so they can form an association. So after forming the association, it becomes the duty of the association to take care of all these things. So the duties and the responsibilities of association are very clearly mentioned in the Societies Registration Act, in the body of that document. So accordingly, each and every allottee is bound to act according to the bylaws of the association. So association is held responsible for maintenance as well as keeping all records related to the unit of apartments. The builder is bound to hand over all the papers, all the documents related to that building or apartment to the association. At the same time, the builder should invariably transfer the common areas categorized in two parts, either first part or second part or both. So it is now the duty of the association to maintain all those things. So it is for the association, they should form a system how to maintain all these things and how the demands of the association are met and what are the duties and responsibilities of the association as well as the members. So in my strong view, the formation of the association should not be a casual one. So in Public Societies Registration Act, there are a lot of loopholes as well as loose ends. So it is better to go for a cooperative society, and the association should act according to the rules framed under cooperative society. And that gives a lot of confidence and well-being of that unit and the well-being of the members also. So as far as Telangana is concerned, this aspect is not being addressed by the government so far. And I am not aware whether the TRADA or any other associations have represented with the government or not. But definitely this is one point where the government should be very firm and very particular also.
Thank you, sir. Vishnu and Raju, sir, thank you for all your information and input about the society registration and also the Resident Welfare Association. Also about the section 17 of the present practices. Certainly, this is the high time for the industry to represent the government, have the clarity on how to register and what would be the process of it. And if any amendment are to be required, considering the present scenario, let us bring it forth in the interest of all the stakeholders, not only the promoters, including the government agencies, including the home buyers and all other stakeholders in the industry in a transparent way and also in the for a long run purposes, sir. Thank you so much for your time and your experience, sir. Certainly, we will come back to you with more of your knowledge and experience on this topic in the coming days to come, sir. Thank you so much.
Welcome. Thank you.
To the organizers, Depending on time which is available, we can take the question and answers. And of course, we are always available to give the answer to any question offline also. It depends on the organizers, the time which is available for the speakers, we can take the question and answer. Over to the organizers. And again, thank you so much for the Mahadev Birla sir and Nipun Singhvi sir for presenting the topic and the subject on RERA sir. Thank you.
Thank you so much, Mr. Thyagaraj and all the panelists for such an informative session. And I can see there are a lot of questions being posed, but few of them have already been replied by you and some other experts. So I think, we can, and then a lot of them are asking for the copy of the presentation. So if everybody agrees, we will then post the session, forward them the copy of the presentation. If all our speakers, our panelists are okay about it. And yeah, there are a couple of it. So Mr. Prem Kumar, do you want to take the Q&A or Mr. Thyagaraj, do you want to take a couple of Q&A?
Sure. I'll take Kathy. Okay, Mr. Nipunji, one of the question which in this session also has come. I received the occupancy certificate and I have not sold any units. I have not borrowed the money also. I have not collected. Still, do I need a RERA registration?
Yes, for future sale, he would require. That would be covered under Section 3.
Okay, the reason is they have mentioned that product is ready for the customers to come and inspect and they can buy it. Why do I need RERA? RERA generally, which is of a stage-wise construction to protect my interest of what is mentioned in the contract document. When the product is ready, why do I need it? This is a standard question, common question. Wherever we go, this would come across. And of course, no exception to this event also. I just wanted your input on this, sir.
Because RERA is not only for construction or a ready possession property, it is also for protecting the interest of the buyer subsequent to that. Like for example, we have talked about structural defect. So if suppose today somebody buys and there is some defect in the structure, so for 5 years he can very well go before RERA and get the grievance resolved. It is not only this, it is also about the title of the property. Suppose today somebody buys and tomorrow he finds out that there is a litigation pending. So that compensation he can claim from RERA. Therefore, this law is designed in such a way that the registration has to be done, even if it is a ready possession property. And recent judgments of Bombay High Court says that even the projects which have not been registered, even then the complainant, if his grievance is falling under RERA Act, can definitely go and knock the doors of RERA. So it is basically, I would say, a beneficial legislation, and therefore the view taken by court is it is applicable.
Okay. Thank you, Nipunji. So in summary, like it's a mandatory for a registration to have for any real estate project the moment it satisfies the condition of the registrable. Second, even though it is not registered, so the buyers can approach the RERA authorities for unregistered project which is to be registerable under RERA. Thank you so much, sir. And Mahadev sir, one more question to you. As Act mandates to register or execute a sale deed within 3 months from date of OC, occupancy certificate. That means to say that, is it a mandatory that without OC, I should not venture into register the sale deed?
No, is it not like that? Even if you have received the payment and you can execute the sale deed before the occupancy certificate also. Only the question comes that it's depend on the state rule, and everywhere I think there is a same rules are there, that unless and until occupancy certificate is there, you cannot hand over the possession because that is illegal. And that's what held by the Maharashtra RERA also in the recent judgment, where they have given the direction that the penalty should be imposed or action should be taken against the allotee also, because they have taken a possession before the occupancy certificate is received. So there is no restriction on the execution of the conveyance deed. Once you have completed your payment, obviously you can go for execution of the sale deed, even occupancy is not received. Occupancy certificate is not received.
Okay, thank you, sir. And Nipunji, the next question is an agreement to sell. The Act mandates to register the agreement to sell, the moment they register, they receive 10%. There is a restriction of receipt of consideration more than 10% without entering into a agreement to sell and also register. So how practical and how mandatory this registration of the agreement to sell, and also what is the practices in other states, and which is more would be relevant to Telangana also, sir?
Sir, mostly in other states, agreement to sell once 10% limit is triggered, they have to get it registered, get it executed. Now, different challenges are coming in most of the states, because when we talk about registration of agreement to sell, we have to go by the registration law of that particular state. Now, registration requires two things in case of immovable property. One is obviously the Registration Act, and second is the stamp duty. So now there are different practices. If you go before registration and suppose there is a duty issue, probably that duty will have to be paid. Now in some states, even the duty is a higher amount. So some of the practices which have evolved over the time period is that to avoid the stamp duty and to keep it between the builder and the buyer, they try to put it less than 10% and get it formalized after completion of payment. In fact, in some of the cases which I have observed, mostly I have been working in northern states, so I have observed that maybe the main project is in X company and they have a Y company. So they make the payment in Y company, show as an advance there, put it before 10% in the actual company, and broadly when the project is completed, they make the payment from outside that company, get it in the main company, and then execute the sale deed. So in this way, people are structuring the transaction. Though
sir, very difficult, sir. The reason is when the bank is involved in terms of funding the housing loan, it's not permitted. Maybe in North India, you will have a lot of cash transaction, or maybe other way of transaction that may be permitted. But here it's very difficult. Second is it's more of the employee category, like people who are working category would be buying most of the apartments. So it's very difficult to have the payment to any other account other than to the builder account because of the legal risk also involved. So considering that, it may not be the
what you are talking is 100% legal and correct. But we all know that there is a on money concept in real estate transactions. Okay, and that is why, in fact, I would talk about the Gujarat state, because we primarily see in Gujarat and in Maharashtra also, in Rajasthan also, I have seen that the major portion of money which is coming for the project is less than what is coming outside.
The project. Okay.
So that is a very big challenge which I always see, and therefore I always suggest to the buyers that keep yourself in a safe mode. Whether you have to pay higher amount of duty, give all the consideration officially and to the company which is giving you the project, not to their group concerned companies. Because nowadays the structuring is service company, they make it different, construction company, they make it different. So you are actually executing different contracts and paying different amount.
Yes, sir. Yes, sir. So one more question to you, sir. In terms of like Section 17 mandates the undivided share of land to the association. Can I go and continue to execute a document with the undivided share to the home buyers?
I did not get exactly what you are asking. Undivided portion to the society or to the
share of land? Undivided share of land. We have a practice in South India wherein undivided share of land would be also be executed to the home buyers. Okay, now Section 17 mandates land should be conveyed to the association. So given the situation, if I execute to the home buyer, there is no land left to execute to the convey to the association. So what's your view on this? Any opinion on this?
I have a very specific view on this, that suppose there is a society, let's say there is a project, there would be two aspects to it. One is whatever flat or apartment we are buying, together with that, we are also buying some facility. Let's say we are buying a parking. We are buying a right to go into the clubhouse. We are also buying a right to walk in the common area. So, undivided portion of land necessary has to be in the agreement. Reason is all these facilities are attached to that undivided portion of land. So, definitely, undivided portion of land has to be mentioned. And if it is not mentioned, it will create problem in future. So it is always insisted that undivided portion of land would be there in the allotment which we are executing. Now, I would tell you, it will have dual impact, not only in RERA, in other laws also, because common area has to be transferred to the association. That is what the law says. Now, if that is not given, how would I exercise my right? So similar thing happened here in Gujarat in one of the matters which we were there, that the land rights and the excess FSI rights were being taken by the developer, by the builder, has been reserved with them, and only a portion of land which you are getting as an allotee was given. So court said that no, you cannot keep the rights with you, and that has to be necessarily gone to the association. So that is how the law sees it.
Okay, fine, sir. Fine, sir. Okay, and
Vinay, this is Shekhar.
Yes, sir.
No, I have some my own doubts, and it's up to all the knowledgeable persons there. See, you have asked the undivided share of the land. See, undivided share of the land, our practice in southern India is that we'll give proportion to undivided share of the land to the flat owner.
Yes, sir.
That is even today is applicable, valid. But the Act says, because I am there from the day one of the draft, nowhere it is discussed. Spirit of the Act I'm saying, spirit of the bill I'm saying. You can interpret it in a different way after it is coming to print. But nowhere in the discussions of several years that undivided share of the land to be transferred or area to be registered in the name of the association is never discussed. Anytime you ask even the government of India, department also, officials are still there. What it says is the common areas which have to be maintained by society has to be handed over, not transferred. The word which is used, even Raju also transferred. It is not transferred. It is handed over. And here also RERA says the society has to be initiated, has to be taken by the promoter to register the society and handed over to the welfare association, handed over the common areas to them for maintenance purpose only. The ownership is all the individuals have the ownership on that. This is why my understanding from the day one. But some people who are not aware of this discussion, deliberations, they are interpreting differently. That is up to them. So another thing is, what my doubt is, see the after OC is there, whether I have to register the project with the RERA. See, earlier our friend has explained the background of this entire real estate comes under the state jurisdiction. Why? How this was there many times? The discussion is there. Then Government of India said there is a contract between the allottee and the purchaser, the promoter. So under the Contracts Act, they have brought in this act. So under Contract Act, they have got it the Real Estate Regulatory. No, not under the real estate. Real estate is a state subject. So now after the OC is there over, it's become a real estate property. Where is the contract? There's no contract. You are physically seeing everything. You are purchasing today. I'm selling it. I'm taking the consideration, seeing the. In my view, I'm a layman. I'm not a legal person. I'm not a legal person. No, as common sense says, as the discussions we participated, it becomes a real estate. Real estate won't attract that portion. There is no contract between. If it is I have to construct and hand it over, there is service is there, contract is there, so many conditions are there. Yes, but it is immobile property. Then tomorrow, all the second and the flats also, when you are selling, then let us go to real estate authority to sell, because there again there is a defect liability is there, so many other things are there. So my personal view is, if the occupant certificate is already there, so you become immobile property, there is no further obligations on the part of the guy. So why should he register with the RERA? That is my personal view. So this is the common area point of view and the RERA point of view. These things are my personal view. I'm very clear, but maybe interpretation point of view, some officials, they are very new. They could not take it what is the spirit of that clause, the section of the clause. They are interpreting their own way. Even phased manner also, developer can take it. They can take 10 blocks at a time, but they can go to the RERA for only 2 blocks. but some RERA official without knowing every background, even it is clearly mentioned in the rules are clearly mentioned, phase wide you can take it, but they are raising objections. In the officials also different opinions also there. So this is what I want to contribute. Thank you.
I have a thought on this. See, well, Mr. Nipun, you just now said that even if the occupancy certificate is obtained, OC is obtained, and you want to sell it, you still have to go to RERA. So once the occupancy certificate is obtained, it falls under transfer of property. It doesn't fall under real estate development. But then, there are a lot of things are being said about this. Mr. Vinay, maybe you can tell us about what happened in Karnataka some time ago, where some developers obtained sanction, and since they were not planning to sell, they didn't go to RERA. But then RERA authorities sent them notices saying that you have to register under RERA. So my question, Mr. Nipun, is, we've had this act for the last, couple of years or more. Have there been any cases that have been adjudicated on this particular issue? Are there any decisions on this?
Yes, sir. There are decisions on this. And in fact, I would like to just change your perception that this law is not only for development, it is also for regulation. So it does not necessarily means that if it is under construction, only then a registration would be required. If you read the definition, it not only says market, book, it also says sell or offer for sale. So if you read the language, it gets covered. And there have been numerous notices. In fact, I would say in Gujarat, previously 80% of projects notices were issued because of this. And today, the level of jurisprudence which is developing in this particular law, we did not have time to discuss the Bombay High Court judgment on this particular aspect. It is in respect of the Bombay Dyeing Company, where the real estate project was not registered and it went till Bombay High Court. The view taken is that retroactive application would be there, and even if it is not registered, forget about registration. Even if it is not registered, even then an allottee can knock the doors of RERA and get the compensation. So that is the level of interpretation which they are taking today. And as of now, till date, what you are saying is a way of interpretation. Till date, there is no Supreme Court judgment on this, which says that this will not be required and this will be required. As of now, the interpretation is it will be required. So the views are like this. And it was first time this RERA Act was challenged in Neelkant Realtors. So this challenge to these sections went till Supreme Court. Supreme Court clubbed it and put it before Bombay High Court. So Bombay High Court ultimately upheld that. And till date, almost after 2.5 years, there is no challenge before Supreme Court. So the view which you are saying probably may be a way of thinking, but the jurisprudence is developing otherwise.
Thank you.
Same in Andhra Pradesh, a notice was issued by RERA to the promoter. He is constructing his own building. He is not selling. Then he approached me. Then I spoke to the RERA authority. They said, if it's really so, let him give a undertaking that he's not selling. That he need not file. He need not register. If he's not really selling, he need not register with us. Let him give an undertaking to that extent.
Okay. This has happened in Hyderabad.
AP.
Yes, sir. Sir, Mr. Nipun is having one more session at 2 o'clock. With the permission of the organizers, I request to end the session by next 2-3 minutes or with the...
Sir, Mahadevji can continue if I may be permitted.
No,
I think we'll also end the session because we were already running over time. I think we were supposed to end at 1 and it's already 1:45. So before we end the session, I would request our Senior Vice President, Mr. Bhaskar Reddy, to kindly propose the vote of thanks. And also with the permission of all our panelists, we will be sharing the PPT. So everyone agrees to it, right? So can we send it to the participants?
I think that Kathy, you need to ask indirectly. Normally, these PPTs are proprietary rights of the panelists, and though this content is public, but the way they make and the way they present the picture, a lot of work goes into it. So the content can be always shared. So which we'll discuss with them, and then whatever is applicable, we can send.
We will share, sir. We will share.
Yeah.
We will not claim copyright, sir.
Okay, thanks. No, because I'm seeing.
But the information, I think I could see enormous interest is evinced by our viewers. I think the content can be shared in whichever way. This is available, I think. So you put a lot of things.
Sure.
And if any Q&A is there, we can collect and we can go forward to the panelists and get the replies.
Yes. I think that's a good idea. If they have any questions, we can forward it to the panelists and they can respond.
No, whatever best possible in consultation with panelists, we can take it up.
Sure, sir. Sure.
Okay. It's my privilege to propose a hearty vote of thanks on the successful conclusion of this webinar, Real Estate Regulation Act, Overview, Legal Aspects and Compliances. First and foremost, I thank our advisors, Sri Shekhar Reddy Garu, past National President, CREDAI, and for a brief while, G. Yoganand Garu was their Chairman and Managing Director of Manjeera Constructions. They are our valued advisors of Infrastructure Committee. Thank you very much for joining us today and motivating our team. I thank Sri Vinay Thyagaraj for excellent moderation, sir, and you are well known to our Telangana real estate sector. I think a lot of talks. Even I happened to hear one of your earlier talks. So thank you very much for taking time and joining us today and putting these things together. And my special thanks goes to today's the show stealers, Mr. Mahadev Birla and Nipun Singhvi. I think you made our viewers' day because the content was so explicit. I could see the interest evinced by all the viewers that everybody is asking for details and questions were flowing in like anything. Had we had time, we would have continued for another hour or so. That kind of interest is generated. Thank you very much for your valuable inputs on this RERA Act. And my special thanks again to Dr. Vardhan Raju Garu, D. Vardhan Raju Garu, former district registrar. Sir, thank you for your wisdom and valuable inputs on the Act, Registration Act particularly. So these are all, I think, RERA Act goes very closely with Stamps and Registration Act also. A lot of intervening things are there. And I thank all our team, FAPSI, Premji, Abhay, Mr. Shyam Sundar Agarwalji, and my colleagues Ramakant and Kathy for joining on this wonderful putting things together and in a so lovely presentation. And I thank members of Managing Committee, past presidents, members of FTCCI for their gracious participation. I also thank press and media. I think we'll be circulating this widely tomorrow for coverage. Last but not the least, I would like to thank our informed audience, without whose participation and involvement no such event is complete. So thank you one and all for joining us today. Thank you.
Thank you, sir. Thanks to all of you. Thank you.
Thank you.
Thank you, everyone.
Thank you.